Sweetheart, you might want to find yourself a real lawyer before you embarrass yourself in there. The words bounce off marble walls, sharp as a slap. Expensive cologne fills the hallway. 3 men in $1,000 suits form a half circle near the courtroom door, their laughter echoing through the corridor like they own the building. The woman in the simple navy dress doesn't flinch. She stands alone, manila folder pressed against her chest, watching the courthouse security camera blink red above the men's heads, recording everything, storing every second of what's about to unfold in a database these men will desperately wish they could erase. Did you hear me? The man steps closer, silver cufflinks flash, wedding ring thick as a knuckle. I'm trying to help you. Walk away now. Save yourself the humiliation. The woman's companion, a broad-shouldered man in a gray sport coat, shifts his weight. Slight movement, almost imperceptible. But his eyes track every body in the hallway, every exit, every angle of approach. The security timestamp reads 8:47:32 a.m. In exactly 4 hours, the man in the expensive suit will be begging. In 6 weeks, his name will appear in federal court documents. In 3 months, his photograph will circulate through every newsroom in Virginia. But right now, he's still laughing. Sterling, leave her alone. A woman in a designer blazer touches his arm. She'll figure it out when the judge throws out her little complaint. More laughter. The bailiff by the courtroom door smirks but doesn't intervene. The woman in navy walks forward, her companion 1 step behind, and the laughter follows her like a shadow she's learned to carry. The bailiff's eyes flick to her companion, just for a moment, and something in his expression shifts. Recognition? Confusion? He looks away too quickly to tell. If you've ever been dismissed by someone who thought you were powerless, hit subscribe, because what happens next in this courtroom will change how you see justice forever. 3 days earlier, the morning had started quietly. Coretta Ashford sat at her kitchen table, spreading documents across the worn wood surface with the precision of someone accustomed to organizing evidence. Contractor invoices, payment receipts, photographs of an unfinished kitchen, text messages printed and highlighted in yellow. The house was modest, a 3-bedroom colonial in Alexandria that she'd owned for 22 years. The furniture was comfortable rather than stylish. The art on the walls was personal rather than impressive. Nothing about the space suggested wealth or status, and that was intentional. Her phone buzzed, a text message from a contact labeled simply D.O. Detail confirmed. 0800. Thursday. She typed back. Understood. Standard protocol. The response came immediately. Copy. Stay safe. Coretta set the phone aside and returned to her documents. The case was simple. A contractor had taken $28,000 for a kitchen renovation, completed $4,000 worth of work, then disappeared. Classic fraud, the kind of dispute that clogged small claims courts across America every day. She could have hired an attorney, could have made a phone call and had this resolved in 48 hours. But that would defeat the purpose. Some lessons needed to be learned the hard way. She organized the exhibits into color-coded tabs, blue for financial documents, green for communications, yellow for photographic evidence, red for legal citations, excessive for small claims court. But habits formed over decades didn't break easily. The morning news played quietly on the kitchen television. A story about police oversight, a city councilman defending his department, the familiar dance of accountability and deflection that she'd watched play out 1,000 times from a very different vantage point. Her phone buzzed again. Different contact. R.S. OIG. Thursday assessment confirmed. I'll be observing Schofield's docket. 3rd case of the month showing pattern. Coretta read the message twice, then deleted it. The wheels were already turning. Had been turning for months. What happened Thursday would either confirm the pattern or prove it coincidental. Either way, she would have her answer. Thursday morning arrived gray and overcast. February in Virginia, the kind of cold that seeped through coat linings and settled into bones. Coretta dressed simply. Navy dress, low heels, minimal jewelry. her hair pulled back in a practical style that suggested efficiency rather than fashion. She checked her reflection once, not for vanity, but for assessment. Did she look like what they expected? Did she blend into the background of people who walked through these doors every day, hoping for justice they might not receive? She looked exactly like what she needed to be, invisible. The Alexandria General District Court occupied a building that had seen better decades. Fluorescent lights buzzed overhead. The floors were clean but scuffed from years of foot traffic. Security lines moved slowly, staffed by personnel who'd learned to treat everyone with the same baseline suspicion. A man in a gray sport coat waited near the entrance. Darnell Okonkwo stood 6'2", with the kind of build that suggested either military service or serious athletic training, both in his case. He wore civilian clothes that fit well enough to move freely, but loose enough to conceal what needed concealing. His eyes never stopped moving. "Morning." His voice was low, professional. "Morning." Coretta fell into step beside him. They didn't embrace, didn't chat, didn't do anything that would suggest their relationship was anything other than coincidental. Two people who happened to be walking in the same direction, toward the same security checkpoint, at the same time. The line moved slowly. Coretta placed her folder and phone in the plastic bin, stepped through the metal detector. Clean. The security officer, a heavy-set man with bored eyes, glanced at her belongings without interest. But when Okonkwo stepped through, something changed. The officer's posture shifted. His eyes sharpened. "Sir, step aside for additional screening." Okonkwo didn't argue, didn't react, just stepped to the designated area and raised his arms for the wand sweep. His expression remained neutral, but Coretta caught the slight tension in his jaw. This happened. It always happened. A black man with his build, his bearing, his way of carrying himself, the system noticed. The system always noticed. The wand beeped near his left hip. The officer's hand moved toward his own weapon. "Pocket knife," Okonkwo said calmly. 3-inch blade. Legal carry. He produced the knife slowly, deliberately, showing his hands at every step. The officer examined it, consulted with a supervisor, then handed it back with a dismissive wave. "You're clear." No apology, no acknowledgement of the 5 minutes lost, while other visitors walked through unchecked. Just the casual assumption that someone who looked like Darnell Okonkwo required extra scrutiny. Coretta waited near the elevator bank. When he joined her, neither mentioned what had just happened. Some things didn't need words. The small claims waiting area smelled like industrial cleaner and anxiety. Plastic chairs lined the walls, filled with people clutching folders and rehearsing arguments in their heads. A young mother trying to recover a security deposit. An elderly man disputing a car repair bill. A couple who'd been scammed by a moving company. Regular people. Small stakes by some measures. Enormous stakes by theirs. Coretta found a seat near the window. Okonkwo sat 2 chairs away, close enough to respond, far enough to seem unconnected. He opened a newspaper. She opened her folder. The door banged open at 8:35 a.m. Sterling Whitmore entered like a man who owned the building and was disappointed by its condition. His suit probably cost more than most of the plaintiffs in this room earned in a month. Behind him came a woman in equally expensive attire, Bridget Loring, according to the case documents, and a paralegal struggling under the weight of 3 document boxes. Overkill for small claims court. Intentional overkill. Whitmore scanned the room with the particular gaze of someone sorting people into categories of useful and worthless. His eyes passed over the young mother, the elderly man, the worried couple, and landed on Coretta. He smiled. It was not a kind smile. "This is what I'm dealing with?" His voice carried easily, meant to be heard. "Some lady with a folder?" Loring touched his arm. "Sterling." "What? I'm just observing. She's sitting there with her little folder, and we brought—" He gestured at the boxes. "An actual case. This will be over in 5 minutes." Coretta continued reading her documents. Didn't look up. Didn't react. Her pen moved across the page, making notes in handwriting so precise it looked typed. Whitmore's smile faltered slightly. People usually reacted to him, usually showed fear or anger, or at least acknowledgement. This woman showed nothing. He found a seat across the room, still watching her with a puzzled expression. Okonkwo turned a page of his newspaper. His eyes tracked Whitmore's position without appearing to move. The clock on the wall ticked toward 9. The deputy clerk's window opened at 8:50 a.m. Coretta approached with her folder, joining the short line of litigants checking in for their hearings. Ahead of her, an anxious man fumbled with paperwork. Behind her, someone's phone played music too loudly until a bailiff silenced it with a look. The clerk, a thin man in his 40s with the pinched expression of someone who'd seen too many people waste his time, glanced at Coretta's paperwork without interest. Case number? GV-2024-00847, Ashford versus Whitmore Development LLC. He typed slowly, hunting for keys. The computer screen reflected in his glasses. Says here your filing fee is still pending. Coretta produced a document from her folder. Bank receipt dated January 28th, transaction ID 7741-alpha-339. $65, processed and cleared. The clerk, his nameplate read N. Fry, examined the receipt like he'd never seen a bank document before. System shows pending. Then the system is incorrect. That receipt confirms electronic transfer completion 4 weeks ago. Fry's expression tightened. He was accustomed to people accepting his word without pushback. Accustomed to litigants who didn't know their rights, didn't keep records, didn't come prepared. Ma'am, I can only go by what the system shows. I understand, and I can only go by what the bank confirms. Would you like me to call the payment processing center while we wait? I have their direct number. She didn't raise her voice, didn't show frustration, just presented options with the calm efficiency of someone who'd navigated bureaucratic obstruction before. Fry glanced toward the courtroom, where Bridget Loring was chatting with the bailiff like old friends. Then he looked back at Coretta. I'll note the discrepancy, but if the magistrate asks, I'll explain. Thank you for your assistance. She took her paperwork and stepped aside. The interaction had lasted 4 minutes. 4 minutes of unnecessary delay, unnecessary questioning, unnecessary doubt cast on documentation that was perfectly valid. Behind her, Whitmore approached the same window. Fry's entire demeanor changed. Mr. Whitmore, everything's in order. Courtroom B 915. Good luck today, not that you'll need it. The two men shared a laugh. Coretta noted the interaction, filed it away alongside the other small indignities that accumulated like interest on a debt nobody wanted to acknowledge. The hallway outside Courtroom B was narrow and poorly lit. Wooden benches lined the walls, occupied by people waiting for their moment of justice or their moment of disappointment. Coretta sat near the window, reviewing her exhibits one final time. Okonkwo stood nearby, studying the fire exit map with the intensity of someone memorizing evacuation routes. Footsteps approached, heavy, deliberate. You know, I admire the effort. Whitmore stood over her, blocking the light from the window. His cologne was overwhelming at this distance, expensive and aggressive, like everything else about him. Really, he continued, coming in here with your little folder, pretending you understand how this works. It's almost cute. Coretta looked up. Her expression was neutral, patient, utterly unimpressed. Excuse me, I need to review my documents. Let me give you some advice. He leaned closer. Free of charge. Drop this nonsense today. Walk away, and I won't countersue for defamation. The threat hung in the air. Other litigants glanced over, then quickly looked away. Nobody wanted to get involved. Defamation requires a false statement of fact. Coretta's voice was calm, measured. Everything in my complaint is documented and true, but I appreciate you putting that threat on record. She glanced at the ceiling, at the security camera with its blinking red light. Whitmore followed her gaze. His smile flickered. You think a camera scares me? I own buildings full of cameras. I know how evidence works. Then you should know that threatening a litigant before a hearing could constitute witness intimidation under Virginia Code Section 18.2-460. The words landed precisely. Whitmore's face went through 3 expressions in 2 seconds: surprise, anger, and something that might have been the first flicker of concern. "Who the hell are you?" "I'm the plaintiff, and you're blocking my light." He stared at her for a long moment, trying to place her, trying to figure out where a woman with a folder and no attorney had learned to cite state code numbers. "Sterling?" Loring appeared at his elbow, smile fixed in place. "We should go in. They're starting." Whitmore let himself be led away, but he glanced back twice. The puzzle bothered him. Something didn't fit. Okonkwo folded his newspaper and moved toward the courtroom door. Coretta gathered her folder and followed. The bailiff, his nameplate read T. Gaines, held the door with exaggerated courtesy for Whitmore and Loring. When Coretta approached, he let it swing closed. She caught it with her folder, stepped through without comment. Some battles weren't worth fighting. Some battles were. This one would be decided inside. Magistrate Harlan Schofield presided over Courtroom B with the enthusiasm of a man counting down to retirement. His reading glasses sat perpetually at the end of his nose. His voice carried the particular drone of someone who'd repeated the same instructions thousands of times and no longer believed any of them mattered. Court is in session. First case, Williams versus Apex Auto Repair. The courtroom was smaller than most people expected. No dramatic architecture, no imposing bench. Just a functional space designed to process cases as efficiently as possible, which often meant as carelessly as possible. Coretta sat in the gallery, watching, learning the rhythms. Magistrate Schofield moved through cases quickly. 5 minutes for the plaintiff, 7 for the defendant. 2 minutes of questions, decision reserved. Assembly line justice. But she noticed patterns. When a young black woman tried to recover wages from a restaurant, Schofield interrupted her twice. When a white business owner countersued for damages, Schofield let him speak for 11 uninterrupted minutes. When an elderly Hispanic man struggled with English, Schofield sighed audibly and suggested he return with a translator. When a white defendant asked for a continuance, Schofield granted it without question. Patterns. Always patterns. Sometimes conscious, sometimes not, but always present. At 9:47 a.m., the case before hers concluded. Schofield shuffled papers with obvious impatience. Ashford versus Whitmore Development LLC. Parties approach. Coretta rose from the gallery and moved toward the plaintiff's table. Whitmore and Loring were already in position, the paralegal arranging their 3 boxes of documents like props in a stage production. Gaines, the bailiff, watched her approach with an expression of mild contempt. "Raise your right hand," Schofield droned. "Do you swear to tell the truth, the whole truth, and nothing but the truth?" "I do." "Counselor?" Schofield looked at Loring. "Opening statement?" "Your Honor, before we begin..." Loring's smile was professionally warm. "I'd like to note that the plaintiff has failed to properly serve my client. We received no certified mail, no personal service, no..." "Objection." Coretta's voice cut through clearly. "Service was completed via certified mail, return receipt signed, 14 days prior. I have the green card." Loring's smile froze. Schofield sighed. "Let's see it." Coretta approached the bench with the document. Her movements were precise, unhurried, the manner of someone who understood that courtrooms had their own tempo. "United States Postal Service certified mail receipt." She read aloud, voice carrying clearly. "Article number 7019-1640-0001-2847-3391, delivered February 2, 2024. Signature, M. Hendricks, Whitmore Development LLC." She placed the green card on the bench. Schofield examined it briefly. "Service appears complete." "Your Honor, we question the authenticity of that signature." Loring recovered quickly. "Our office manager's name is Hendricks, but we'd need to verify..." "Counselor, it's a certified mail receipt signed at your client's place of business. Motion denied. Proceed, Ms. Ashford." First, small victory, but Loring's expression promised more challenges ahead. The hearing should have been straightforward. Coretta had documentation for everything: signed contract, payment receipt, text messages showing Whitmore's broken promises, photographs of the untouched kitchen, BBB complaints, DPOR disciplinary records. A reasonable magistrate would have seen the case clearly. Schofield was not interested in seeing clearly. Ms. Ashford, summarize your complaint in 2 minutes. She'd watched Whitmore's opening statement. It had taken 7 minutes, with multiple interruptions for clarifying questions that were actually opportunities for Whitmore to expand his narrative. 2 minutes. Coretta didn't argue, didn't show frustration. She'd prepared for this. On November 3, 2023, I contracted with Whitmore Development LLC for a kitchen renovation. Total cost, $57,000. I paid a deposit of $28,500, 50%, as specified in the contract. She placed the contract on the evidence table. Mr. Whitmore promised work would begin November 20th. That date passed. He promised December 4th. That date passed. I have text messages documenting 8 separate promised start dates between November and January. The text message log joined the contract. On January 10, 2024, I inspected my property. Original cabinets, original countertops, original flooring. No work had been performed. I sent a formal demand letter requesting a refund of my deposit. Mr. Whitmore did not respond. She placed the demand letter and the photographs on the table. I'm asking the court to order a refund of my deposit, $28,500, plus filing fees and delay damages as specified in paragraph 14 of the contract. She sat down. 97 seconds. Schofield was already looking at his watch. Mr. Whitmore, response? Whitmore rose slowly, buttoning his jacket with the practiced casualness of a man who knew he had all the time he needed. Your Honor, this is a simple misunderstanding. My company has completed over 200 projects in the greater Washington area. We have an A rating with the Better Business Bureau. We don't defraud our clients. We work with them through the complexities of construction scheduling. He smiled at the gallery, playing to an audience that wasn't really there. Ms. Ashford signed a contract, yes. She paid a deposit, yes. But that contract included a force majeure clause covering supply chain delays. The materials for her kitchen, custom cabinets from Italy, specialty countertops from a manufacturer in Montana, were delayed due to factors beyond our control. Loring handed him a document. He waved it vaguely in Coretta's direction. We have purchase orders showing we ordered her materials. We have shipping manifests showing delays. We have... I'd like to see those documents, Coretta's voice cut through clearly. Schofield frowned. Ms. Ashford, you'll have an opportunity for rebuttal. I'm asking to examine the documents he's referencing, opposing party disclosure. Loring's smile tightened. Your Honor, we'll submit these as Exhibits D1 through D15. Then I'd like to review them before Mr. Whitmore continues his testimony. Rule 3. A 15 permits inspection of documentary evidence before cross-examination. Silence. Loring glanced at Whitmore. Schofield's frown deepened. Ms. Ashford, are you an attorney? No, Your Honor. I prepared my own case, as is my right in small claims court. Then perhaps you should let the court manage procedure. I understand. But I believe I'm also entitled to review evidence presented against me before it's accepted into the record. Another silence. Schofield's jaw worked like he was chewing something unpleasant. Bailiff, provide the plaintiff with the defendant's exhibits. 5 minutes to review. Gaines crossed the courtroom slowly, as if the distance were miles instead of feet. He handed Coretta the stack of documents with elaborate disinterest. She reviewed them methodically, page by page, making notes, watching Whitmore's expression shift from confident to curious to something approaching concern. If you think she's just looking at papers, you haven't been paying attention. What she finds next is going to change everything. Subscribe and stay for the reveal. The documents were creative, she had to admit. Purchase orders dated November 5, 2023, 2 days after contract signing. shipping manifests showing delays from Italian suppliers, email chains discussing material substitutions, all very professional, all very organized, all very fake. Coretta knew they were fake because she'd done her homework. Your Honor, I've completed my review. Schofield glanced up from whatever he'd been reading, certainly not the case documents. Proceed. I have questions about Exhibit D3, this purchase order for Italian cabinets, dated November 5, 2023. Whitmore nodded confidently. Custom Milanese design, very high-end. The supplier listed is Milano Cucine Internazionale. That's correct. Coretta produced a document from her folder. I conducted a business entity search through the Italian Chamber of Commerce database. There is no company registered under that name in Italy. Never has been. The courtroom went quiet. Additionally, the address listed, via Giuseppe Verdi 47 Milan, is a residential apartment building. I have a Google Street View screenshot showing the location. No commercial activity, no cabinet manufacturing. She placed the documents on the evidence table. The purchase order appears to be fabricated. Whitmore's face flushed red. You can't just... Sterling, Loring's voice was sharp. Let me handle this. She rose smoothly, smile intact despite the obvious damage. Your Honor, Ms. Ashford's internet research is not authenticated evidence. She has no personal knowledge of Italian business registries. This is hearsay. Coretta didn't hesitate. I also have a declaration from the commercial attaché at the Italian embassy in Washington, confirming no such business is registered. Declaration under penalty of perjury, notarized and apostilled. She produced the document. Schofield stared at it like she'd produced a live snake. You contacted the Italian embassy for a small claims case. I contacted every source necessary to verify Mr. Whitmore's claims, including the Virginia Department of Professional and Occupational Regulation, which I mentioned earlier. She produced another document. DPOR case log for Whitmore Development LLC, license number 2705-047831. Complaints filed, 14. Complaints resulting in investigation, 9. Complaints resulting in disciplinary action, 3. Most recent action, letter of reprimand, October 2023, failure to complete contracted work. Whitmore was on his feet. This is harassment. She's digging through my business records. These are public records, Coretta replied calmly. Available to any citizen through a FOIA request. I have the response letter from DPOR dated January 15, 2024. Loring's smile had vanished entirely. Your Honor, we request a recess to review these documents. Schofield hesitated. He'd clearly expected this case to be simple. Wealthy businessman versus ordinary citizen, 5 minutes and done. The ordinary citizen wasn't cooperating. 15-minute recess. Parties will remain in the building. His gavel came down hard enough to echo. The hallway was crowded with people seeking water fountains and restrooms. Coretta found a quiet corner near the emergency exit and reviewed her notes. Footsteps approached. Heavy, aggressive. Who the hell do you think you are? Whitmore's voice had lost its smooth confidence. His face was flushed, his tie loosened, his posture radiating barely controlled rage. I'm the plaintiff in case GV 202400847. Coretta didn't look up. As I mentioned earlier. You know what I mean. He stepped closer, crowding her space. Italian embassy? Business registry searches? Who puts together that kind of case for a small claims dispute? Someone who was defrauded by a contractor and wants their money back. This isn't about money. His voice dropped lower. This is personal. Someone sent you. Who was it? A competitor? A former employee? Coretta finally looked up. Her expression was utterly calm, utterly unreadable. No one sent me, Mr. Whitmore. I'm a citizen exercising my legal rights. That seems to confuse you. He stepped closer still, close enough that she could see the veins pulsing in his temple. Let me tell you something. His voice was a hiss now, meant only for her ears. I know people. Judges, prosecutors, police chiefs. I make one phone call and your life becomes very, very complicated. Is that a threat? It's a promise. Coretta reached into her jacket pocket and produced a small device. Silver, no larger than a button. This is a digital recorder. It's been running since I entered this building. Everything you've said to me today, including that promise, is now documented. Whitmore's face went white. Your Honor. Coretta pitched her voice to Carrie. Schofield was passing through the hallway, coffee in hand. The defendant just threatened to use his political connections to retaliate against me. I have it recorded. Schofield stopped. Other litigants turned to watch. Loring emerged from the restroom just in time to witness her client frozen mid-confrontation. Mr. Whitmore, step away from the plaintiff. She's lying. I have a recording, Your Honor. I'm happy to play it for the court. Whitmore stepped back. His hands were shaking, with rage or fear impossible to tell. This isn't over, he muttered. Actually, Coretta said quietly, it's just beginning. The recess stretched to 30 minutes, then 45. Loring was on her phone in the hallway, speaking rapidly in hushed tones. Whitmore paced like a caged animal, glaring at anyone who made eye contact. Okonkwo appeared near the water fountain, newspaper tucked under his arm. Everything okay? His voice was low, professional. Under control. He touched you? Invaded my space. Didn't make contact. I saw. Had eyes on the whole time. Coretta nodded. The camera in that corner caught it. Third one from the stairwell. Okonkwo glanced in that direction. Red light blinking. You're building a record. I'm documenting what happened. What happens next is up to them. The bailiff appeared in the hallway. Court reconvenes in 5 minutes. All parties to courtroom B. The atmosphere had shifted when they returned. Schofield sat at his bench with the expression of a man who'd had an unpleasant phone call. Loring's smile was gone entirely. Whitmore slumped in his chair, tie undone, looking like a man who'd already lost. Only the bailiff, Gaines, seemed unaffected, watching from his post near the door with the same mild contempt he'd shown all morning. We're back on the record in Ashford versus Whitmore Development LLC. Schofield's voice had lost its dismissive edge. Before we continue, I want to address the incident in the hallway. He looked at Whitmore. Mr. Whitmore, courthouse decorum requires that parties refrain from approaching each other outside supervised settings. Any further violations will result in sanctions. Is that understood? Whitmore nodded without looking up. Ms. Ashford, you mentioned a recording. The court does not permit unauthorized recording of proceedings. The hallway is not a courtroom, Your Honor. Virginia is a one-party consent state for audio recording. I was party to the conversation. The recording is legal. Schofield's jaw tightened. She was right, and he knew it. Noted. Let's continue with the testimony. Loring rose slowly, gathering what remained of her composure. Your Honor, in light of the questions raised about our documentation, we'd like to request a continuance. We need time to... Objection. Coretta's voice was firm. This is the defendant's 4th request to delay. I have documented 3 previous continuances already granted, totaling 4 months. Virginia Code Section 16.1-88.03 limits. Continuances to prevent abuse of process. Schofield's eyebrows rose. You know the code section? I prepared thoroughly, Your Honor. Silence. Loring's expression suggested she was recalculating everything she thought she knew about this case. Motion for continuance denied. We'll conclude testimony today. The first real victory, small but real. The afternoon session became a dismantling. Coretta presented her evidence methodically, each exhibit building on the last. Bank records showing the wire transfer. Text messages showing broken promises. Photographs time-stamped by her phone's GPS. the BBB complaint marked unresolved, the DPOR disciplinary record, the Italian embassy declaration, and then the final exhibit. I'd like to present Exhibit P14, Your Honor, a sworn declaration from Marcus Hendricks, office manager at Whitmore Development LLC. Loring was on her feet immediately. Objection. We weren't notified of this witness. It's a declaration, not live testimony. No witness notification required under small claims procedure. Coretta's voice was patient, almost gentle. Rule 16.1-78 specifically permits sworn written statements in lieu of witness appearance. She handed the document to the bailiff for delivery to the bench. Mr. Hendricks was deposed as part of a separate civil matter, Thornton v. Whitmore Development, case number 2023-CV4847, Fairfax County Circuit Court. His deposition testimony includes statements about company practices regarding construction contracts. Schofield was reading the document with actual attention now. Ms. Ashford, how did you obtain this? Court records are public, Your Honor. I retrieved the transcript from the Fairfax County Clerk's office. She produced the receipt. Mr. Hendricks testified under oath that Whitmore Development routinely collects deposits for work they have no intention of completing. He described a pattern of material orders that exist only on paper, fabricated purchase orders used to justify keeping deposits when clients demand refunds. The courtroom was utterly silent. He also testified that Mr. Whitmore personally directed him to create false documentation for at least 6 client disputes in the past 2 years. Whitmore was on his feet. He's a disgruntled employee. He was fired for... Sterling! Loring's voice cracked like a whip. Sit down, now. He sat, but his eyes burned with a rage that went beyond courtroom decorum. Schofield set down the document. His expression had shifted from indifference to something approaching genuine attention. This is substantial evidence, Ms. Ashford. I'm surprised opposing counsel wasn't aware of this prior testimony. I'm surprised as well, Your Honor. Coretta's voice was neutral, but the implication landed. Loring's face flushed. She'd been caught unprepared, or caught knowing and hoping it wouldn't surface. We'll need to verify the authenticity of this document, she managed. I have the case number. You can verify it with Fairfax County Clerk's office before this hearing concludes. Schofield nodded slowly. We'll take a brief recess while counsel makes that verification. The verification took 12 minutes. When court reconvened, Loring's face told the story before she spoke. Your Honor, we've confirmed the deposition transcript is authentic. However, we'd note that Mr. Hendricks's testimony in that matter is subject to appeal and, Counselor, Schofield's voice had an edge now. The testimony exists. The pattern described matches what the plaintiff has documented. Are you suggesting this court should ignore evidence of systemic fraud? Loring hesitated. The pause lasted too long. I'm suggesting we might explore a settlement. Coretta leaned back in her chair. The first genuine surprise of the day. A settlement, Schofield repeated, now that the evidence is on the table. My client is prepared to refund the deposit in full. We can have a check issued by end of business. No. Coretta's voice was calm but firm. The contract specifies delay damages at $150 per day. From November 20th to today, that's 93 days. $13,950 plus the deposit refund, plus my filing fees and documentation costs. That's extortion, Whitmore snarled. It's the contract you signed, Mr. Whitmore. Coretta produced the document. Paragraph 14, Delay Damages Clause, your signature at the bottom. Would you like to see it? Gaines, the bailiff, shifted his weight. Something flickered in his expression. Coretta caught it, filed it away. Your Honor. Loring's voice had gone flat, all professional warmth drained. We'll need to discuss settlement terms privately with our client. You have until 4 p.m. today. If terms aren't agreed, I'll issue a ruling based on the evidence presented. Schofield gathered his papers. We're in recess until then. The afternoon crawled by in silence and tension. Coretta sat in the hallway, reviewing her notes, occasionally checking her phone. Okonkwo maintained his position nearby, not obviously protective, but present, watchful. At 2:15 p.m., Gaines approached. "Ma'am?" His voice was different now, softer, almost nervous. "Courtroom's not ready yet. You'll need to wait outside." The sign says proceedings resume at 2:15. It's 2:14. Magistrate's orders. I see. Coretta made a note on her phone. And Mr. Whitmore? Is he also waiting outside? Gaines didn't answer. Through the courtroom door window, she could see Whitmore and Loring already inside, conferring with papers spread across the table. "I'll wait." Gaines retreated to his post. But something had shifted in his demeanor. Less contempt, more caution. He'd watched the morning session. He'd seen what happened when people underestimated this woman. At 2:23 p.m., the door finally opened. "You can come in now." Coretta gathered her folder and entered. The settlement conference was brief and brutal. Loring presented an offer. Full deposit refund, no delay damages, mutual release of claims. Take it or leave it. Coretta rejected it. "The contract is clear. My client is prepared to honor the delay damages clause he wrote into his own agreement." That clause was never intended. Intent doesn't override written terms, counselor. Your client is an experienced developer. He knew what he was signing. Back and forth, point and counterpoint. Loring tried legal arguments, emotional appeals, veiled threats about the cost of continued litigation. Coretta responded with documentation, every point backed by evidence, every claim supported by paper. At 3:47 p.m., Whitmore cracked. "Fine." His voice was a snarl. $45,000, deposit plus damages plus fees. But I want her to sign a non-disclosure agreement. She doesn't talk about this case. Ever. Coretta considered. The amount was accurate, actually slightly more than she'd calculated. "I'll sign a non-disclosure regarding financial terms, but I won't agree to conceal the existence of this dispute or the documented pattern of fraud." Then no deal. Then we proceed to ruling, and the magistrate's findings become public record. Whitmore's face went purple. Loring put a hand on his arm. "We need a moment, Your Honor." Schofield nodded. "The court will take a 10-minute recess." The hallway was empty now. Most of the day's litigants had finished their cases and gone home, some satisfied, most disappointed. The wheels of small claims justice ground slowly and often ground the wrong way. Coretta stood near the window, watching the gray February sky. Okonkwo appeared beside her. "They're going to take the deal." "Probably." "You pushed hard." "I pushed accurately. There's a difference." He was quiet for a moment. Then, "The bailiff, Gaines. He moved your exhibits during the first recess." Coretta nodded. "I noticed. The signed contract went missing from my folder for about 3 minutes. It reappeared after you spoke to him." I reminded him that evidence tampering in a court proceeding carries specific penalties. "What did he say?" "He said he found it under a clipboard." "And you said?" "I said security cameras don't lose things under clipboards." Coretta almost smiled. Almost. "They're connected. Gaines, Fry, probably others. They run interference for people like Whitmore. Make the system harder to navigate for people like me." "You navigated it anyway." "I had resources most people don't. That's the problem." The courtroom door opened. Loring's face was carefully neutral. "We'll accept your terms. Non-disclosure on financial details only. $45,000. Coretta nodded. "I'll need the agreement in writing before I sign anything." Standard settlement form. The magistrate has them. They returned to the courtroom. The settlement agreement took 30 minutes to execute. Standard language. Mutual release of claims. Payment within 14 business days. Non-disclosure limited to specific financial terms. Both parties signed. The magistrate witnessed. As Whitmore scratched his signature across the final page, his hand trembled visibly. "This isn't over," he muttered, quiet enough that only Coretta heard. "On the contrary." She gathered her copies of the agreement. "This matter is concluded." She stood, collected her folder, nodded to the magistrate. "Thank you for your time, Your Honor." Schofield's expression was unreadable. He'd clearly expected this case to go differently. A quick dismissal, a wealthy defendant vindicated, an ordinary citizen put in her place. Instead, he'd witnessed something that looked uncomfortably like the system working correctly. "Court is adjourned." His gavel came down one final time. The lobby was nearly empty at 4:30 p.m. Coretta walked toward the exit, Okonkwo falling into step beside her. The security guards barely glanced up as they passed. Outside, the February air was sharp and cold. Gray sky threatening rain, cars crawling through rush-hour traffic. "Where to?" Okonkwo asked. "Home. I have work tomorrow." He didn't ask what work, didn't need to. They walked toward the parking garage in silence. Two people who might be strangers, might be colleagues, might be something else entirely. A car pulled up beside them. Black SUV, tinted windows. The driver's window rolled down. "Judge Ashford?" Coretta stopped. Okonkwo's hand moved toward his hip, subtle, automatic. The woman in the driver's seat held up a credential. "FBI, Special Agent." "I'm Agent Torres. Director Shelton asked me to check in, said you might have something for us." Coretta glanced at Okonkwo. He gave a slight nod. "I have documentation of a pattern. Clerk and bailiff coordinating to obstruct pro se litigants. Possible connection to political figures the defendant mentioned." Agent Torres nodded. "We've had our eye on this courthouse for 6 months. Today's footage will help." "The security recordings?" "Already preserved. We have people inside." Coretta absorbed this. The wheels had been turning longer than she'd realized. "Is this why I was assigned a protective detail?" "That's a separate matter. The corruption investigation and the threats against you. They're different cases, but they may be connected." Torres handed her a card. "If anything else develops, that's my direct line. And Judge, be careful. Whitmore has friends. Some of them wear badges." The window rolled up. The SUV pulled away. Coretta stood in the parking garage, watching the taillights disappear. The drive home was quiet. Okonkwo navigated traffic while Coretta reviewed her notes. The settlement agreement, the recorded threats, the documentation of clerk and bailiff misconduct. Pieces of a puzzle she'd been assembling for months. "You knew," he said finally. "Coming in, you knew they'd try to obstruct you." "I suspected. The pattern or practice complaints going back 3 years. The statistical disparities in case outcomes. The consistent reports from pro-SE litigants about lost evidence and missing files. So this wasn't just about a kitchen renovation. The renovation was real. The fraud was real. But yes, I was also gathering evidence." "For?" "For a civil rights complaint. 18 U.S.C. Section 242, deprivation of rights under color of law." Okonkwo processed this. The FBI has been building a case. And now they have more documentation, firsthand, from someone whose testimony will be difficult to dismiss. "Because you're a federal judge." "Because I'm a federal judge who experienced exactly what ordinary citizens experience every day. Without the title, without the deference, without the assumption of competence." She looked out the window. Streets she'd driven 1,000 times. A city she'd helped govern for 15 years. Most people don't have a marshal escort. Most people don't have law degrees or connections to the FBI. They just have their little folders and their hope that the system will work. Does it work? Sometimes. Not often enough. But maybe we can improve the odds. They arrived at Coretta's home as darkness fell. The house was as she'd left it, modest, comfortable, unremarkable. Okonkwo did a security sweep while she made tea, checked windows, doors, sight lines, the routine of protection that had become part of her daily life. "Clear," he reported. I'll be in the vehicle until the night shift arrives. Rotation at midnight. Thank you, Deputy. He nodded, started toward the door, then paused. Judge, what he said. About knowing people. Judges, prosecutors, police chiefs. I heard him. That wasn't a bluff. Coretta set down her tea. I know. That's what makes this dangerous and necessary. Okonkwo held her gaze for a moment. Then he left, closing the door softly behind him. Coretta stood in her kitchen, the one with original cabinets, original countertops, original flooring. The renovation she'd never wanted. The fraud she'd allowed to happen because it gave her a reason to walk through that courthouse door as an ordinary citizen. Her phone buzzed. A text from RS-OIG. Footage secured. Schofield's pattern confirmed. Formal review initiated. She typed back, timeline? Weeks, maybe months. System moves slowly. I'm aware. She set the phone aside and looked around her kitchen. The settlement money would arrive in 14 days. She'd donate it, the whole $45,000, to legal aid organizations serving pro-C litigants. Money that would help people navigate a system designed to defeat them. It wasn't enough. It was never enough. But it was something. The next morning, Coretta returned to her chambers in the federal courthouse. The space was everything the small claims courtroom wasn't. High ceilings, polished wood, the weight of history and authority in every corner. Her nameplate on the door, Honorable Coretta R. Ashford, Senior U.S. District Judge. Her clerk, a young woman named Priya, looked up as she entered. Good morning, Judge. The Morrison briefs are on your desk, and you had 3 calls from a Sterling Whitmore? I didn't return them. Don't. If he calls again, direct him to my staff attorney. Understood. Priya hesitated. There was also a courier delivery. Envelope, no return address. She handed it over. Plain manila, standard size. Coretta's name typed on a label. When did this arrive? Around 7:30. Security scanned it, nothing flagged. Coretta waited until Priya left before opening the envelope. Inside, a single photograph. Herself, entering the small claims courthouse. Okonkwo circled in red marker. On the back, handwritten in block letters, we know he's not always there. Coretta sat at her desk for a long time, looking at the photograph. The threats against her had started 6 months ago, shortly after she'd been assigned the Morrison case. A massive public corruption prosecution involving city officials, police commanders, and a network of developers who'd been siphoning federal housing funds for years. The defendants had resources, connections, people who specialized in making problems disappear. She'd refused to recuse herself. The case was clean, no conflicts, no personal connections, just evidence and law and the machinery of justice grinding forward. The threatening letters had started a week later. Anonymous, untraceable, specific enough to make clear they were watching. The marshals had assigned a protective detail. Okonkwo, professional, competent. A reminder that some cases carried physical risks. But this photograph was different. It had been taken yesterday, at the small claims courthouse, a building where she'd appeared without title or authority. Someone had been watching. Someone had been documenting. And now someone wanted her to know. She photographed the envelope and its contents, forwarded everything to the threat assessment team. Then she picked up the phone and called the one number she'd hoped she wouldn't need. Director Shelton, it's Judge Ashford. We need to talk. The Morrison case file sat on her desk, thick with accusations and evidence. City officials who'd steered contracts to connected developers. Police commanders who'd looked the other way. Millions in federal funds diverted to private pockets. Sterling Whitmore's name appeared on page 47, not as a defendant, as a witness, a developer who'd received contracts during the period under investigation, someone the prosecution wanted to question about bidding processes and payment structures. Coretta read the section 3 times. The connection wasn't obvious. Whitmore wasn't accused of anything in the Morrison case, but his company had benefited from the same corrupt system the prosecution was trying to expose. And now, less than 24 hours after she'd defeated him in small claims court, someone had delivered a threatening photograph to her chambers. Coincidence? No. In her experience, coincidences were just connections you hadn't traced yet. She made notes, drew lines, built the map in her mind. This is where ordinary stories end. But Coretta Ashford isn't ordinary, and neither is what happens next. Subscribe now, because Part 2 reveals the truth behind that photograph. The rest of the morning passed in routine work, briefs to review, motions to consider, the machinery of federal justice requiring constant attention. But Coretta's mind kept returning to the photograph, to Whitmore's face when he'd made his threats, to the casual corruption she'd witnessed in that small claims courtroom, the clerk who obstructed, the bailiff who sabotaged, the magistrate who tilted scales. A system designed to work for some and against others, a system protected by people who benefited from its failures. At noon, her phone buzzed. Agent Torres. Judge Ashford, we've analyzed the photograph. And? The image was taken from across the street. Professional equipment. Someone who knew what they were doing. Surveillance. Correct. We're pulling traffic camera footage from the area. If someone was positioned there for an extended period, we might get a face. Might. These people are careful, but they make mistakes eventually. Everyone does. Coretta thought about Sterling Whitmore, confident and laughing in that courthouse hallway, convinced that his money and connections made him untouchable. Yes, she said, they do. At 3 p.m., Okonkwo appeared at her chambers. Shift change briefing. His voice was professional, but his eyes told a different story. The night team reported movement at your residence. Coretta set down her pen. What kind of movement? Vehicle. Passed your house 3 times between 11 p.m. and 2 a.m., different routes each time. License plate? Obscured, deliberately. They knew where the streetlights were. She absorbed this. The threat was escalating, moving from anonymous letters to surveillance photographs to physical proximity. What do you recommend? Enhanced detail. 2 instead of 1. Residence and chambers both covered around the clock. And if that's not enough, then we consider relocation, temporary, until the threat is neutralized. Coretta shook her head. I won't be driven from my home or my work. That's exactly what they want. Judge, I understand the risks, but capitulation only invites more threats. We proceed normally while your teams do their work. Okonkwo's jaw tightened. He disagreed, but he was professional enough not to argue. Understood. I'll coordinate the enhanced detail. He left. Coretta turned back to the Morrison file. Somewhere in these pages was the connection. The reason someone had chosen yesterday to photograph her. The reason Sterling Whitmore had been so confident about his connections. She would find it. She always did. Evening came slowly. Coretta worked until the building emptied, until the cleaning crews had come and gone, until the only sounds were the hum of ventilation and the distant traffic of a city settling into night. At 7:30, she gathered her files and prepared to leave. Her phone buzzed. Text from Okonkwo. Ready when you are? Front entrance. She rode the elevator down alone. The lobby was empty except for security, a guard who nodded as she passed. Outside, the black SUV waited. Okonkwo at the wheel, another marshal, someone she didn't recognize, in the passenger seat. This is Deputy Marsh. Okonkwo gestured. He's on your detail now. Enhanced protocol. Coretta nodded to Marsh. Thank you for your service. Ma'am. His voice was clipped, professional. They drove through streets that should have been familiar, that now felt different. Watched, monitored. Every passing car a potential threat. Every shadow a hiding place. This was her life now. Would be her life until the Morrison case concluded, until the threats were traced and stopped, until the people who wanted her silence were themselves silenced by the weight of evidence and law. The drive took 20 minutes. No unusual vehicles, no signs of surveillance. But when they pulled into her driveway, Okonkwo stopped short. "Stay in the vehicle." He was out the door before she could respond, hand on his weapon, eyes scanning the house. The front door was open, not broken, open, as if someone had walked in and left it that way. Marsh was on his radio, calling for backup. Okonkwo approached the house slowly, weapon drawn, moving with the precise economy of someone trained for exactly this situation. Coretta watched from the SUV, heart steady, mind racing. They'd come to her home, walked through her door, left it open for her to find. A message, a demonstration, a promise of what they could do whenever they chose. She thought of Sterling Whitmore's voice. This isn't over. No, it wasn't. But it would be. One way or another. The house was empty. Okonkwo cleared every room while Marsh secured the perimeter. Nothing missing, nothing damaged. Just the open door, a violation without evidence, a threat without proof. Almost. In the kitchen with original cabinets, original countertops, original flooring, someone had left a gift. A single rose, black petals, artificial, and beneath it, a note typed on plain paper. Drop the case. Last warning. FBI forensics arrived at 9 p.m. They photographed everything, dusted for prints, collected the rose and the note for analysis, interviewed neighbors who'd seen nothing, heard nothing, noticed nothing. Agent Torres supervised personally. Same pattern as the Morrison threats, she said. Black rose is their signature. We've seen it before, in cases connected to the developer network. So this confirms the connection. It confirms someone wants you scared, whether that's Whitmore, Morrison's other defendants, or someone else entirely. We're still working on. How did they get in? Lock wasn't forced. Either they had a key or they picked it professionally. Either way, they wanted you to know they could access your space whenever they wanted. Coretta looked around her kitchen, her home, the place that was supposed to be sanctuary. I'm not dropping the case. We didn't expect you would. Torres handed her a card. But we're recommending you stay somewhere else tonight. Hotel. Family. Anywhere they haven't mapped. They've probably mapped everything. Then we make them work harder. Coretta spent the night in a hotel room downtown. 2 marshals in the hallway, cameras on every exit, the paranoid precautions of someone whose life had become a target. She didn't sleep. Instead, she reviewed the Morrison file again, page by page, looking for the thread that connected Sterling Whitmore to the larger conspiracy. She found it at 3 a.m., a subsidiary company, buried in footnotes, a shell corporation that had received funds from the same sources the prosecution was investigating. The shell corporation was registered to an address in Alexandria, the same address as Whitmore Development LLC. Morning came gray and cold. Coretta showered, dressed, prepared for the day ahead. Court business wouldn't wait for threats or sleepless nights. The machinery of justice required constant attention. But first, she made a phone call. Director Shelton, I found something. She explained the connection, the shell corporation, the shared address, the thread that tied Sterling Whitmore not just to a small claims dispute, but to a federal corruption investigation. Shelton was quiet for a long moment. You understand what this means. He's not just a witness. He's potentially a target. If that's true, his behavior yesterday, the threats, the intimidation, makes more sense. He wasn't just angry about losing a small claims case. He was protecting something larger. Something he's afraid I'll find. Something he's afraid you've already found. Coretta thought about the photograph, the open door, the black rose. He knows I'm the Morrison judge. He might have known before you filed the small claims case. You think I was targeted? I think it's worth considering. A federal judge who happens to be assigned to a case involving a developer, That same judge files a personal complaint against that developer in state court? The coincidence is remarkable. Coretta processed this. Had Whitmore known who she was all along? Had his fraud been intentional, not just business as usual, but a specific trap? If he knew who I was, why take the contract? Same reason people commit most crimes. They think they won't get caught. They think their power protects them. She thought of his face in the courtroom, the confidence that had slowly crumbled, the rage when he realized she'd outmaneuvered him. He didn't expect me to fight back. Most people don't. That's what he was counting on. The federal courthouse felt different that morning. Same building, same routines. But Coretta walked through the halls with new awareness, watching faces, noting movements, wondering who else might be watching her. Priya was already at her desk when Coretta arrived. "Good morning, Judge. More calls from Whitmore's office, and Director Shelton wants to speak with you urgently. I spoke with him an hour ago. He called again, said there's been a development." Coretta picked up the phone. "Director?" "Judge Ashford. We've made progress on the photograph. Traffic cameras caught a vehicle near the small claims courthouse at the time the image was taken. We ran the plates." "And?" "The vehicle is registered to a security company. The security company is a subsidiary of a larger firm. That firm has contracts with the city, specifically with the police department." Coretta felt the pieces clicking into place. The same police department connected to Morrison. "Correct. We believe the surveillance wasn't personal. It was institutional. Someone in the network ordered eyes on you. Because of the case. Because of what you might find. And now that we know Whitmore is connected to the network, your small claims victory becomes more significant. It exposes a weakness. It exposes a crack, and cracks can be widened. The Morrison case would take months to reach trial. In the meantime, Coretta had work to do, cases to decide, justice to administer. The daily grind of federal jurisprudence that never stopped for threats or investigations. But beneath the routine, the larger pattern continued to emerge. Whitmore's company, the shell corporation, the security firm, the police department, the city officials. A web of connections that protected itself through intimidation, obstruction, and the casual abuse of power. The same pattern she'd witnessed in the small claims courtroom. Clerk obstructing, bailiff sabotaging, magistrate tilting scales, small corruptions enabling larger ones. And at every level, the same assumption that ordinary people would give up, would accept defeat, would walk away rather than fight. Most people did. Coretta Ashford was not most people. At noon, Okonkwo appeared at her chambers. Update on the residence. Forensics found partial prints on the doorframe, running them now. How long? 24 to 48 hours. And if they match someone in the system? Then we have a name, a starting point. She nodded. Small steps. Incremental progress. The slow grind of investigation that people on television never understood. There's something else. Okonkwo hesitated. Agent Torres flagged a financial transaction. Sterling Whitmore liquidated assets yesterday afternoon. Moved significant funds offshore. How significant? $2.3 million, to accounts in the Caymans. Coretta absorbed this. A man who'd been confident of victory was now moving money, preparing for something. He knows we're looking at him. He knows something, whether it's the FBI investigation, the Morrison connection, or just general paranoia. He's acting like someone who expects trouble. Or someone who's planning to run. Okonkwo met her eyes. That's one interpretation. And the other? Someone who's planning to fight. The afternoon brought more pieces of the puzzle. Agent Torres called with forensic results from the Black Rose. Synthetic fabric. Commonly available. Untraceable, except for one detail. The manufacturing lot number matched roses purchased by a florist in Alexandria. The florist's records showed a cash purchase 2 days before the break-in. The buyer had been recorded on security camera. A woman. Blonde. Professional attire. Torres sent the image to Coretta's secure phone. Bridget Loring, Sterling Whitmore's attorney. The implications crystallized slowly. Loring hadn't just represented Whitmore in small claims court. She'd participated in threatening a federal judge, had personally purchased materials used to intimidate a judicial officer. That wasn't attorney-client privilege, that was conspiracy. "Do we have enough?" Coretta asked Torres. "For questions, yes. For charges, not yet. We need to tie the rose purchase to the actual placement. Right now, she could claim she bought it for personal use." "And the break-in?" "No prints matching Loring, but the lock was picked by someone with professional training. We're looking at the security company, whether they provided personnel." "The same security company connected to the police department." "Same one." Coretta set down the phone. The web was wide, deep, protected by layers of deniability and institutional power. Dismantling it would take months, maybe years. But every thread she pulled loosened the structure. Every connection she exposed made the next exposure possible. At 5 p.m., something unexpected arrived. A delivery to her chambers. This time, properly processed through courthouse security. A legal-sized envelope with a return address she recognized. The Virginia State Bar Association. Inside, a formal notice. In the matter of attorney Bridget Loring, bar number 47,821. Complaint filed alleging violation of Rule 8.4, D, conduct prejudicial to administration of justice. Investigation opened. Response required within 30 days. The complaint had been filed by a third party, anonymous. But Coretta recognized the language, the precise citations, the methodical documentation. Someone else was watching Loring. Someone else had decided to act. She thought about the small claims courtroom, the other litigants who'd been rushed, dismissed, obstructed, the people who'd lost cases they should have won because the system worked against them. Maybe one of them had finally found their voice. Or maybe the web was starting to unravel from within. The phone on her desk rang. Direct line, no caller ID. Coretta hesitated, then answered. "Judge Ashford." A voice she didn't recognize, male, measured. "You've been asking questions about Sterling Whitmore." "Who is this?" "Someone who knows what you're looking for, and knows you won't find it through official channels." "I'm not interested in unofficial channels." "You should be. The network you're investigating, it's bigger than you think. Whitmore is just the face. The real power is behind him." "Then tell the FBI what you know." A laugh, soft, humorless. "The FBI has people in the network too, Judge. Not many, but enough. You file a report, it might reach the wrong desk." Coretta's grip tightened on the phone. "Why are you calling me?" "Because you're the first person in years who actually fought back. The first person who didn't fold when Whitmore pushed. That makes you dangerous to them." "And to you?" "I'm already dead, Judge. Officially, I died in a car accident 3 years ago. The network made me disappear when I tried to expose them the first time." Coretta's mind raced. A source, an insider, someone with knowledge of the corruption she was investigating. "What do you want?" "I want what you want. Justice. The difference is, I know where the bodies are buried, literally and figuratively." "Then help the investigation." "I will, but not through channels they can monitor. There's a safety deposit box at Virginia National Bank, box 1447. The key is in your mailbox at home, the real one, not the federal courthouse. Inside the box, you'll find documents that tie Whitmore to Morrison, and Morrison to others who haven't been named yet." "How did you get a key into my mailbox?" "I have friends, more than you'd think. People who want this network exposed but are too afraid to act openly." "And you're not afraid?" "I told you, Judge. I'm already dead. Fear is for people who still have something to lose." The line went dead. Coretta sat motionless for a long time. The call changed everything, confirmed everything. A network so deep it had people in the FBI. So powerful it could make witnesses disappear. So arrogant it had tried to intimidate a federal judge, but someone inside was fighting back. Someone who'd been silenced once and refused to stay silent. She picked up her phone, called Okonkwo. "I need you to check my mailbox. At home. There may be something there." "On my way." 20 minutes later, he called back. "There's a key. Safety deposit box. No note, no explanation. Virginia National Bank, box 1447. "How did you know?" "Someone told me where to look." "Who?" "I don't know yet, but I intend to find out." The documents arrived the next morning. Okonkwo retrieved the safety deposit box contents with FBI supervision. Chain of custody maintained. Everything by the book. Inside, financial records spanning 5 years, wire transfers, shell corporations, real estate transactions, names that matched the Morrison investigation, and names that hadn't appeared yet, including 3 sitting judges, 2 city council members, and the deputy police chief. The network was larger than anyone had suspected, and Sterling Whitmore, the man who'd laughed in a courthouse hallway, was just the first domino. Coretta stood at her window, looking out at the city she'd sworn to serve. The investigation would take months, years. There would be resistance, obstruction, threats. Some guilty parties would escape. Some innocent people would suffer. But the wheels were turning, evidence accumulating, patterns emerging. And somewhere out there, a dead man was watching, waiting, ready to expose the rest. Her phone buzzed. A text from an unknown number. "The first domino has fallen. Watch for the others." She looked at the photograph on her desk. Herself entering the small claims courthouse. Okonkwo circled in red. They'd meant it as a threat, a demonstration of power. But they'd miscalculated. Badly. Because Coretta Ashford wasn't ordinary, wasn't easily intimidated, wasn't willing to bend. And now she had something they hadn't expected. She had evidence. She had allies. And she had the patience to wait for justice, however long it took. The network had tried to silence her with a photograph. She would answer with the truth. End of Part 1. Part 2 arrives tomorrow, where the anonymous source leads Judge Ashford into the heart of the conspiracy. Subscribe now so you don't miss the moment everything changes. The safety deposit box documents spread across the conference table like pieces of a puzzle finally finding their edges. Coretta stood at the head of the table, watching FBI analysts sort through 5 years of financial records, wire transfers, shell corporations, property deeds, email printouts with names redacted in black marker, but not redacted well enough. "This is significant." Agent Torres held up a spreadsheet. "We've got money flowing from city contracts through 4 different LLCs before landing in offshore accounts. The trail is deliberately complicated, but it's traceable. How long to trace it fully? Weeks, maybe months, but we've already identified 3 principals we didn't have before." She pointed to photographs pinned on the evidence board. 3 faces Coretta recognized, 2 city council members and a deputy police chief, the same names the anonymous caller had mentioned. "What about Whitmore?" "He's the funnel. Every transaction we've analyzed so far passes through his company at some point. He takes a percentage, cleans the money through construction contracts, and distributes it to the network. And he's been doing this for 5 years. At least, probably longer. We're still pulling records." Coretta studied the evidence board. Names connected by red string. Photographs arranged in hierarchies of power and culpability. A conspiracy that reached into every corner of city government. And at the center of it all, Sterling Whitmore, the man who'd laughed at her in a courthouse hallway. "What about the source?" she asked. "The person who provided these documents?" Torres shook her head. "Nothing yet. The key was clean. No prints, no DNA. Whoever delivered it knew what they were doing. They said they were dead. Officially. A car accident 3 years ago. We're pulling records. Anyone connected to the network who died in the past 5 years, It's a long list. Coretta thought about the voice on the phone. Calm, measured, the voice of someone who'd accepted certain truths about their situation. They're still out there, watching, waiting. You think they'll make contact again? I think they already have plans we don't know about yet. The morning briefing ended at 10. Coretta returned to her chambers to find Okonkwo waiting in the hallway, his expression more tense than usual. Problem. What kind? Whitmore's attorneys filed an emergency motion this morning. They're claiming harassment, seeking a restraining order against the FBI. On what grounds? Malicious prosecution. They say the investigation is retaliation for the small claims case, that you're using federal resources to pursue a personal vendetta. Coretta absorbed this. The network was fighting back, not with threats this time, but with lawyers and legal process, turning the system against itself. Who's the judge assigned? That's the problem. Okonkwo's jaw tightened. Judge Harold Becker, Eastern District. The name landed like a blow. Harold Becker, Bridget Loring's father. The connection Coretta should have seen immediately. He should recuse. He hasn't. Motion hearing is scheduled for tomorrow morning. That's a conflict of interest. His daughter is under investigation for her role in threatening me. The motion doesn't mention Bridget Loring. It's framed entirely as Whitmore versus the FBI. Her name doesn't appear. Coretta understood. They'd structured the filing deliberately, keeping Becker's daughter out of the record to avoid triggering automatic recusal, a technical workaround that any competent judge would see through, unless that judge didn't want to see. We need to file a motion to recuse, immediately. Already drafted, Torres is handling it, but Judge Becker has discretion on whether to consider it before the hearing. And if he doesn't? Then we have a hostile judge deciding whether the FBI can continue investigating his daughter's client. Coretta walked to her window. The city spread out below, buildings and streets and people who had no idea how deep the corruption ran. They're coordinating, Whitmore, Loring, Becker, using the legal system to protect themselves. It's what they do, what they've always done. And it's worked, for years, until now. She turned back to face him. Get me everything on Harold Becker. Case history, financial disclosures, any connection to the network we're investigating. You think he's involved? I think his daughter bought a black rose that ended up in my kitchen. I think his client is laundering money for half the city council. I think coincidence only goes so far. The afternoon brought new complications. A courier arrived at 3 with documents from the Virginia State Bar, Bridget Loring's formal response to the ethics complaint. 26 pages of denial, deflection, and counter-accusation. Coretta read it twice, noting the strategy. Loring claimed she'd purchased the rose as a gift for a friend. Claimed she had no knowledge of any break-in. Claimed the complaint was itself harassment, coordinated by unknown parties seeking to damage her career. The response was aggressive, confident, written by someone who believed the system would protect her. She's good. Priya stood in the doorway, reading over her own copy. The legal arguments are solid. Without hard evidence tying her to the actual placement of the rose, it's her word against forensics. And forensics doesn't have her prints at my house. Correct, just the purchase receipt, which she's explained away. Coretta set down the document. What about the security company, the one that picked my lock? Still investigating. Torres says they've identified 3 employees with lock-picking training. One of them has connections to the police department. Connections how? Former officer. Retired early after an internal investigation that went nowhere. Name? Victor Holt. 22 years on the force. Left 3 years ago with full pension. 3 years. The same timeline the anonymous caller had mentioned. The same period when someone had supposedly died in a car accident. Pull everything on Holt and cross-reference with any deaths in that window. Deaths? Traffic accidents specifically. Anyone connected to investigations that got shut down. Priya nodded and left. Coretta turned back to the window. The web was widening. Every thread she pulled revealed more connections, more names, more pieces of a conspiracy that had been operating in plain sight for years. And somewhere in that web, someone was waiting to help her tear it apart. The recusal motion failed. Judge Harold Becker denied it the next morning, citing insufficient grounds. His written opinion ran 3 paragraphs: perfunctory, dismissive, legally questionable, but not obviously reversible. The harassment hearing proceeded as scheduled. Coretta wasn't present. Her role in the investigation required her to maintain distance from the legal proceedings. But Torres called with updates throughout the morning, her voice growing increasingly frustrated. "He's railroading us. Every objection overruled. Every piece of evidence questioned. Whitmore's attorneys are practically writing his opinions for him." "Is there a record?" "Full transcript, court reporter, but the damage is happening in real time." At 11:30, the hearing concluded. Becker ruled from the bench, a temporary restraining order prohibiting the FBI from harassing Sterling Whitmore or any employee of Whitmore Development LLC. The investigation wasn't dead, but it was wounded. "We'll appeal," Torres said. "The Fourth Circuit will see through this." "How long?" "Expedited? 3 weeks. Standard? 3 months. 3 months. An eternity in an investigation where evidence could disappear and witnesses could be silenced. What about the documents from the safety deposit box? Still admissible. They weren't obtained through the investigation Becker just restricted. Different chain of custody. So we work around him. We work around him, but carefully. He's watching now. They all are. The anonymous source made contact again that evening. Same method. Unknown number. Same calm, measured voice. "You saw what they did today." Coretta stood at her hotel window. She'd been relocated after the break-in. Her home now a crime scene under 24-hour surveillance. "I saw a judge protect his daughter's client. I saw the system work exactly as designed." "Not as designed, as corrupted. There's a difference." "Is there?" "You're the proof that there is. You fought back. You're still fighting. And you're still hiding." A long pause. Traffic sounds in the background. Wherever the caller was, they were outside. Moving. "I'm not hiding. I'm positioning. There's a difference." "Position for what?" "The next move." Becker's ruling bought them time, but it also exposed them. He didn't recuse when he should have. That's reversible error. The appeals process takes months. The appeals process takes whatever time we let it take, but there are other paths. What kind of paths? The kind that don't go through Judge Becker, the kind that go over him. Coretta waited. The caller seemed to be deciding how much to reveal. "There's a hearing tomorrow. Virginia Judicial Conduct Board. Magistrate Harlan Schofield, the one from your small claims case. He's been reviewed before, 3 times. Nothing ever came of it." "I know about the review. Inspector Shields filed the report." "Shields works for the Office of Inspector General. She's thorough, but she's also constrained. The board is stacked with people who owe favors to the network." "Then why mention it?" "Because tomorrow's hearing is public. Media allowed. And the evidence Shields compiled includes footage from your small claims case. Footage that shows Schofield treating you differently because of how you looked. Footage that doesn't identify who I am." "Exactly. To the board, you're just another pro-se litigant who got railroaded. Another example of a pattern they've ignored for years. But if my identity came out, it would change everything. A federal judge, subjected to the same discrimination ordinary citizens face every day. The story writes itself." Coretta understood. The caller was suggesting she reveal herself, not in the controlled environment of a federal proceeding, but in the chaos of a public hearing. That's a significant step. It's the only step that matters. Becker can block the FBI. He can protect Whitmore. He can use procedure to slow everything down until the evidence disappears and the witnesses forget. But he can't control public opinion. He can't stop the story once it's out. And if the story backfires, if I'm seen as the one coordinating harassment, then you lose. But you were already losing. Slowly. Quietly. The way they want you to lose. The caller paused. When they spoke again, their voice was softer. You didn't back down in that courtroom. You stood there with your folder and your evidence, and you beat him. You beat Sterling Whitmore at his own game. That matters. That means something. It doesn't mean enough. It means everything. Because you showed it's possible. You showed that someone can fight back and win. If you reveal who you are tomorrow, if you let the world see what they did to a federal judge, you change the conversation. You make it impossible to ignore. Coretta looked out at the city lights, buildings and streets and people who deserved better than the system they'd been given. I'll think about it. Don't think too long. The hearing starts at 9. The line went dead. The caller is right about one thing. Tomorrow changes everything. But whose side are they really on? Subscribe now, because what happens at that hearing will shock you. Sleep didn't come. Coretta lay in the hotel bed, staring at the ceiling, running scenarios through her mind. The anonymous caller's logic was sound. Going public would shift the narrative, would make the network's tactics visible in a way that legal proceedings couldn't. But it would also make her a target in a different way. No longer a quiet threat, operating through proper channels. A visible symbol, a rallying point, and symbols could be attacked. At 4 a.m., she gave up on sleep, made coffee in the room's tiny kitchenette, reviewed the documents from the safety deposit box one more time. The financial trail was damning. Money flowing from city contracts through Whitmore's shell corporations to offshore accounts controlled by council members and police officials. A perfect machine for converting public funds into private wealth. But the machine had operators, people who made decisions, who signed documents, who looked the other way, people who'd been protected for years by a system designed to protect them. She thought about Magistrate Schofield, the way he'd rushed her testimony while letting Whitmore speak at length, the way he'd dismissed her objections while sustaining every challenge from opposing counsel. The small, systematic bias that would be invisible in any single case but became undeniable across dozens. The pattern Inspector Shields had documented. The pattern the Judicial Conduct Board had ignored 3 times before. How many people had Schofield treated the same way? How many had walked out of his courtroom confused and defeated, believing the system simply didn't work for people who looked like them? She picked up her phone, dialed a number she'd memorized but never used. Judge Ashford. Inspector Ramona Shields answered on the second ring. I wondered if you'd call. You knew about my case. I knew you filed as a pro se litigant. I knew Schofield was on my investigation list. When I saw your name on the docket, I made sure to be there. And you didn't tell anyone who I was. That wasn't my role. I was there to document patterns, not to influence outcomes. What happened in that courtroom needed to happen exactly as it did, without anyone knowing who you really were. Coretta absorbed this. Shields had been building a case, using Coretta's experience as one data point among many. Your report goes to the board today. At 9, along with 6 months of documentation, statistical analysis, and video evidence from courthouse security cameras. And you expect the same result as the previous 3 reviews. Shields was quiet for a moment. I expect the board to do what they've always done. Acknowledge concerns, recommend retraining, and move on. That's how the system protects itself. Unless something changes. Unless something changes. Coretta looked at the city lights through her window, the first hints of dawn touching the horizon. What if I testified? At the hearing, as myself? That would be unprecedented. Would it help? It would transform the hearing into national news, a federal judge describing discrimination she experienced in state court. The implications would be impossible to ignore, and impossible to control. Yes, once you reveal yourself, you can't unreveal. The story becomes bigger than any single proceeding, bigger than the board, bigger than Schofield, bigger than me. That's the risk, and the opportunity. Coretta thought about Sterling Whitmore, about Bridget Loring and Judge Harold Becker, about the network that had been operating in plain sight for years, protected by people who benefited from its existence, about the anonymous caller who'd said, "You showed it's possible. You showed that someone can fight back and win." "I'll be there," she said. 9 o'clock. "Judge Ashford, I'll be there." She ended the call, set down the phone, watched the sun rise over a city that was about to learn something it had never imagined. The Virginia Judicial Conduct Board met in a hearing room on the 4th floor of the State Supreme Court building in Richmond. The space was designed for transparency, public seating, media section, witness table facing the 5-member panel. But transparency, Coretta had learned, meant nothing if the people conducting hearings didn't want to see what was in front of them. She arrived at 8:45, wearing a simple gray suit, different from the navy dress she'd worn in small claims court, but equally unremarkable. Okonkwo had argued against her attendance. Torres had expressed concerns about security. Director Shelton had reminded her of the ongoing investigation and the need for operational discretion. She'd listened to all of them. Then she'd made her decision. The hearing room was already filling when she entered. Journalists in the media section, notebooks and recorders ready. Court observers in the public gallery, some genuinely interested in judicial accountability, others present because they'd heard whispers that something significant might happen. Magistrate Harlan Schofield sat at the respondent's table, flanked by 2 attorneys, one from the court system, one private counsel. His expression was the same mild indifference she remembered from the small claims hearing. The expression of a man who expected this process to end the same way it had ended 3 times before. Inspector Shields sat at the presentation table, organizing documents with methodical precision. She glanced up as Coretta entered, gave an almost imperceptible nod, then returned to her materials. Coretta found a seat in the public gallery, 3rd row, aisle seat. Close enough to see faces, far enough to remain unremarkable. For now. The hearing began precisely at 9. Board Chairman Theodore Marsh, silver-haired, distinguished, 20 years on the bench before retirement, called the proceedings to order. His voice carried the particular gravity of someone who took their role seriously while understanding the practical limits of his authority. This hearing concerns Magistrate Harlan Schofield, assigned to Alexandria General District Court. The Office of Inspector General has filed a formal report alleging patterns of disparate treatment toward pro se litigants. Inspector Shields, you may proceed with your presentation. Shields rose, adjusted her glasses, and began. Thank you, Chairman Marsh. Over the past 6 months, my office has conducted a comprehensive review of Magistrate Schofield's docket. We analyzed 342 cases heard between July 2023 and January 2024, focusing on hearing duration, objection rulings, and outcome patterns. She pressed a button on her laptop. The screen behind her displayed a spreadsheet, columns of numbers, color-coded by demographic category. Our analysis reveals statistically significant disparities in how Magistrate Schofield treats litigants based on representation status and apparent demographic factors. The first slide showed hearing times. Pro se litigants received an average hearing duration of 6.2 minutes. Represented parties received 14.8 minutes on average. That's a difference of 8.5 minutes. Time to present evidence, respond to objections, and receive fair consideration of their claims. The second slide broke the data down further. When we analyzed by apparent race of the litigant, based on visual identification from court recordings, the disparity became more pronounced. Litigants of color received an average hearing time of 5.1 minutes, regardless of representation status. White litigants received 11.3 minutes on average. Murmurs from the gallery. Schofield's attorneys were already making notes, preparing objections, finding weaknesses in the methodology. We also analyzed objection rulings. When pro se litigants raised objections, Magistrate Schofield sustained them 14% of the time. When represented parties, particularly those with established relationships with the court, raised objections, he sustained them 68% of the time. She advanced to the next slide. Case outcomes. Pro se litigants won their cases 31% of the time in Magistrate Schofield's courtroom. The statewide average for similar courts is 47%. The discrepancy is not explained by case complexity or evidence quality. Schofield's private attorney, a sharp-featured man named Carlton Webb, rose immediately. Objection to the characterization of evidence quality. Inspector Shields has no basis for determining whether the cases that lost deserve to lose. Chairman Marsh nodded. Inspector Shields, respond to that concern. We conducted a qualitative review of 50 randomly selected cases from Magistrate Schofield's docket. In 23 of those cases, the losing party presented documentary evidence that was never examined, objections that were overruled without explanation, or testimony that was cut short before completion. I have examples prepared for the board's review. She pulled up the first video. Coretta recognized the courtroom immediately. The fluorescent lights, the worn wood of the bench, the particular way Schofield slouched in his chair when he wasn't actively interested in what was happening. On screen, an elderly black man was attempting to present evidence in a landlord-tenant dispute. Schofield interrupted him 3 times in 40 seconds. "Sir, I've heard enough, but I have receipts showing I paid." "The landlord's records show different. Motion granted." "I have the canceled checks right here." Motion granted. Next case. The video ended. Another began. A young Hispanic woman trying to recover wages from a restaurant. Schofield allowed the employer's attorney to speak for 6 uninterrupted minutes. When the woman tried to respond, he cut her off after 90 seconds. "Ma'am, do you have a lawyer?" "No, sir. I can't afford—" "Then I suggest you find one before making accusations you can't support." Case dismissed without prejudice. Video after video. Pattern after pattern. The same dynamic repeating. Deference to those with power. Dismissal of those without. Coretta watched Schofield's face. He showed no reaction to the footage. No embarrassment. No recognition that he was watching himself deny justice to people who had trusted the system to protect them. He simply looked bored. The morning session lasted 3 hours. Shields presented data, video evidence, and sworn declarations from litigants who'd experienced the disparities she'd documented. The board asked questions, some probing, some skeptical, some clearly designed to create grounds for dismissing the findings. Schofield's attorneys responded with technical objections, challenged the statistical methodology, questioned whether the witnesses were credible, argued that judicial discretion was protected and that second-guessing a magistrate's case-by-case decisions violated separation of powers. The arguments were familiar, the same defenses that had worked 3 times before, the same system protecting itself. At 12:30, Chairman Marsh called a lunch recess. "We'll reconvene at 1:30. Inspector Shields, do you have additional witnesses?" "I have 3 additional witness statements to present, Chairman, and I've received notification that 1 witness wishes to testify in person." Marsh raised an eyebrow. "We didn't receive notice of live testimony." "The witness came forward this morning. She was a litigant in Magistrate Schofield's courtroom in February and wishes to describe her experience directly." Schofield's attorney was on his feet. "Objection. We have a right to prepare for cross-examination. Springing a witness at the last minute." "The witness's identity will be disclosed during the lunch break. You'll have adequate time to prepare." Marsh considered, then nodded. "I'll allow it. The board will reconvene at 1:30 with live testimony." The room began to empty. Journalists headed for the hallway, phones already out. Court observers compared notes in hushed voices. Coretta remained in her seat. Inspector Shields approached, file folder in hand. "Judge Ashford, are you certain about this?" "I'm certain it's necessary." "The board may not respond the way you hope. They've protected Schofield before. They may protect him again." "Then at least the protection will be visible. At least the public will see exactly who's making that choice." Shields studied her for a moment. Then she nodded. "I'll notify counsel. Testimony begins at 1:30. The lunch break passed in a blur of activity. Okonkwo positioned himself near the hearing room entrance, watching everyone who came and went. Torres sent updates from the FBI field office. Whitmore's attorneys had filed another motion, this time seeking to quash the subpoenas based on the restraining order. The legal maneuvering was accelerating. Coretta sat in a small conference room, reviewing her notes. Not legal arguments. She wouldn't be presenting legal arguments, just memories, experiences, the things she'd seen and felt in that small claims courtroom. At 1:15, Carlton Webb appeared at the door. Schofield's private attorney. His expression was careful, controlled, but something flickered beneath the surface. "Judge Ashford?" She looked up. "Mr. Webb? I must say, this is unexpected. A federal judge testifying against a state magistrate. Quite the spectacle you're creating. I'm describing my experience as a litigant, nothing more. Your experience as a litigant who happened to be conducting surveillance on my client's courtroom, who coordinated with the FBI and the Inspector General to manufacture a controversy. I coordinated nothing. I filed a legitimate small claims case. What happened in that courtroom was entirely your client's choice." Webb's smile was thin. "The board will see it differently. They'll see a powerful federal official using her position to attack a state court employee. David and Goliath, except you're Goliath pretending to be David. I'm a citizen who was treated unfairly. Everything else is context." "Context matters, Judge. Context is everything." He left. Coretta returned to her notes. At 1:25, she walked back to the hearing room. The gallery was fuller than before. Word had spread during the break. Journalists who'd treated the morning session as routine were now sitting forward, alert to the possibility of something significant. Court observers had multiplied. The air crackled with anticipation. Coretta took her seat in the witness section. Front row, facing the board. Behind her, she could feel eyes. Curious, skeptical, waiting. Chairman Marsh called the hearing to order. "We're back on the record in the matter of Magistrate Harlan Schofield. Inspector Shields, you indicated you have a witness who wishes to testify." "Yes, Chairman. I call Coretta Ashford." Coretta rose and walked to the witness table. Sat down, adjusted the microphone. The room was silent except for the scratch of pens and the soft click of camera shutters. "Please state your full name and occupation for the record." "Coretta Ruth Ashford. I'm a senior United States District Judge for the Eastern District of Virginia." The reaction was immediate. Gasps from the gallery, journalists reaching for phones. Even Chairman Marsh's practiced composure flickered. Carlton Webb was on his feet. "Objection. This is a complete ambush. A federal judge testifying in a state disciplinary proceeding. The conflict of interest alone—" "There is no conflict of interest." Coretta's voice was calm, carrying clearly through the room. "I appeared in Magistrate Schofield's courtroom as a pro se litigant. I experienced the same treatment Inspector Shields has documented. I'm here to describe that experience. You're here to destroy my client's career as retaliation for a case you won. I won because I had evidence and I knew my rights. Most people who appear in that courtroom have neither advantage. That's the problem." Marsh held up a hand. "Mr. Webb, your objection is noted. Judge Ashford, you understand that your testimony may raise questions about federal-state judicial relations?" "I understand. I'm prepared to address any concerns the board has." "Very well. Inspector Shields, proceed." The testimony lasted 45 minutes. Coretta described arriving at the courthouse, the clerk who'd challenged her filing fee, the bailiff who'd hidden her exhibit, the attorney who'd mocked her in the hallway. She described the hearing itself, how Schofield had rushed her testimony while allowing the defendant unlimited time, how he'd sustained every objection from opposing counsel while overruling every objection from her, how he'd treated her not as a citizen seeking justice, but as an obstacle to be processed and dismissed. She described the physical intimidation, Whitmore blocking her path, crowding her space, the shoulder contact that was just aggressive enough to feel threatening without being obviously illegal. And she described her companion, the man in the gray sport coat who'd watched everything without intervening. "At the time," she said, "I was under protective detail from the U.S. Marshals Service. I'd received threats related to a case I was presiding over. Deputy Marshal Darnell Okonkwo accompanied me to the courthouse." Webb leaned forward. "So you had federal protection, a U.S. Marshal at your side, and you're claiming you were vulnerable?" "I'm claiming I was treated exactly the way I would have been treated without the protection. Magistrate Schofield didn't know who I was. The clerk didn't know. The bailiff didn't know. They treated me the way they treat everyone who walks through those doors without an expensive attorney or a powerful name." "That's speculation. You can't know how they treat other litigants." "I watched 6 cases before mine. I saw the pattern: short hearings for unrepresented parties, dismissive language, objections overruled without explanation. Inspector Shields' data confirms what I witnessed." Webb shifted tactics. "You filed this small claims case knowing you would be in front of Magistrate Schofield. You knew he was under investigation. This was entrapment." "I filed a legitimate claim against a contractor who defrauded me. The case was assigned to Magistrate Schofield's docket through normal court procedures. I had no control over the assignment." "But you knew Inspector Shields was investigating him." "I learned that after I filed. And it didn't change anything. The case was real. The fraud was real. What happened in that courtroom was real." Webb pressed harder. "You're a federal judge. You have resources most litigants can't imagine. You had FOIA requests, Italian embassy contacts, deposition transcripts from other cases. How is your experience comparable to an ordinary citizen?" Coretta leaned forward slightly. Her voice remained steady, but something sharpened in her expression. "I had those resources because I knew where to look. Because I'd spent 30 years learning how the legal system works. But the documentation I gathered, the DPOR complaints, the BBB reports, the prior lawsuit testimony, all of that was public information, available to anyone who knew how to find it." She paused. "The question isn't why I was able to access that information. The question is why most people can't. Why the system makes it so difficult for ordinary citizens to gather evidence that should be freely available. Why someone without legal training, without time off from work, without childcare and transportation, and all the other privileges I had, why that person would have lost the exact same case I won." Webb opened his mouth to respond. She didn't let him. "Magistrate Schofield didn't know I was a federal judge. He saw a black woman with a folder. That's what he based his treatment on. Not my qualifications, not my evidence, not my legal arguments. Just what I looked like standing in front of him." She turned to face the board directly. "That's the pattern Inspector Shields documented. That's what 342 cases show. Not explicit racism. Magistrate Schofield probably doesn't think of himself as racist. But implicit bias, unconscious assumptions about who deserves attention and who doesn't, who's credible and who isn't, who belongs in a courtroom and who's just wasting time." She let the words settle. "I beat Sterling Whitmore because I had evidence and I knew how to use it. But I shouldn't have had to be a federal judge to get a fair hearing. No one should." That testimony just changed everything. But the network isn't going to let this slide. What happens next will push Coretta to her limits. Subscribe now. The confrontation is coming. The cross-examination was brutal. Carlton Webb abandoned any pretense of professional courtesy. His questions were designed not to elicit information, but to discredit, to undermine, to reframe Coretta's testimony as the vendetta of a powerful official against a defenseless magistrate. "Judge Ashford, you're aware that your testimony today will be reported nationally?" "I assume so." "And you're aware that this attention will benefit your career, position you as a crusader for justice?" "I'm not seeking attention. I'm describing what happened." "But you are seeking something. You filed a complaint with the State Bar against Bridget Loring, the attorney who represented Mr. Whitmore." "I documented her conduct. The bar filed its own complaint based on independent evidence." "And the FBI is investigating Mr. Whitmore, investigating his company, seeking to freeze his assets?" "I'm not directing the FBI's investigation. But you're connected to it. You're the reason it's happening. I'm a witness to certain events. What the FBI does with my testimony is their decision." Webb smiled. A predator's smile, designed to signal victory to the jury even when victory wasn't certain. "So you're just a witness, a federal judge who happens to witness things, who happens to file complaints, who happens to appear at hearings, all coincidence. All consequence. There's a difference. Enlighten us." Coretta took a breath, centered herself. "When you abuse power long enough, you create enemies. Not because those enemies are vindictive, but because, eventually, you abuse the wrong person. Someone who knows how to fight back. Someone who has the resources and the determination to expose what you've been doing." She looked directly at Webb. "I'm not the first person Sterling Whitmore defrauded. I'm not the first person Magistrate Schofield treated unfairly. I'm just the first one who could do something about it." Webb's smile faltered, just for a moment. "That sounds like revenge. That sounds like justice. I understand if you can't tell the difference." The board deliberated for 2 hours. Coretta waited in the conference room, checking her phone for updates from Torres and Okonkwo. The FBI investigation was proceeding despite Judge Becker's restraining order. They'd found workarounds, alternative jurisdictions, ways to continue building the case without directly contacting Whitmore or his employees. The financial trail was expanding. More names, more connections. The network was larger than anyone had suspected. At 4:30, Chairman Marsh called the hearing back into session. The gallery had thinned slightly. Some journalists had filed preliminary stories. Others had moved to the hallway to make calls. But enough remained to ensure that whatever happened next would be witnessed, recorded, reported. Marsh's expression was unreadable as he shuffled papers and consulted briefly with his fellow board members. "This board has reviewed the evidence presented by Inspector Shields and the testimony provided by Judge Ashford. We've also considered the respondent's defense and the objections raised by counsel." He paused. The room held its breath. The evidence of disparate treatment is substantial. Statistical analysis, video documentation, and first-hand testimony all point to a pattern of conduct that fails to meet the standards expected of Virginia's judiciary. Schofield, for the first time, showed emotion. His jaw tightened. His hands gripped the table edge. "However," Marsh's voice remained measured, "this board must also consider the broader implications of our decision. Magistrate Schofield has served Alexandria General District Court for 18 years. His docket is among the heaviest in the state. He processes thousands of cases annually under significant time pressure." Coretta felt her stomach tighten. The familiar pivot, the system preparing to protect itself. "We find that the evidence supports a pattern of implicit bias that warrants serious attention. Magistrate Schofield is hereby ordered to complete 40 hours of implicit bias training within the next 6 months. Additionally, his cases will be subject to random audit for a period of 18 months, with monthly reports submitted to this board." Schofield's attorneys were already relaxing, the minimal sanction they'd expected, business as usual. "However," Marsh's voice sharpened slightly, "this board is not convinced that training alone will address the concerns raised. The testimony of Judge Ashford, a sitting federal judge who experienced discriminatory treatment in Magistrate Schofield's courtroom, represents a level of documentation we cannot ignore." He looked directly at Schofield. "Magistrate Schofield, this is your 4th appearance before this board. 3 previous reviews resulted in recommendations that were clearly not implemented with sufficient seriousness. This pattern cannot continue." The room went silent. "Therefore, in addition to the training requirement and audit period, this board is issuing a formal censure. This censure will be made part of your permanent judicial record. Any future complaints, if substantiated, will result in immediate suspension proceedings." Schofield's face went white. A censure wasn't removal, but it was damage. Permanent, public damage to a career he'd expected to ride comfortably into retirement. "This hearing is adjourned." The aftermath erupted before Marsh finished speaking. Journalists rushed for the exits, phones already out. Webb gathered his papers with barely controlled fury. Schofield sat frozen, staring at the table as if he couldn't process what had just happened. Inspector Shields approached Coretta, her expression cautiously satisfied. "Not everything we hoped for, but more than we expected. It's a start. The censure will follow him. Any future complaints will be taken seriously now. And the audit means someone's actually watching." Coretta nodded. Small steps. Incremental progress. The slow grind of accountability that people on television never understood. But she'd learned something important today. The system could be moved. Not easily, not quickly, not completely, but moved. By evidence. By testimony. By refusing to let patterns stay invisible. Judge Ashford. Webb materialized at her elbow, smile back in place. "Congratulations on your victory. Enjoy it while it lasts." "Is that a threat, counselor?" "It's an observation. You've made powerful enemies today. People who don't forget. People who don't forgive." "I've been receiving threats for months, Mr. Webb. One more doesn't change my calculus." "These threats won't come in letters or photographs. They'll come in legal filings, ethics complaints, questions about your conduct, your decisions, your fitness for the bench." He stepped closer, close enough that she could smell the coffee on his breath. "You think you've won, but all you've done is paint a target on yourself. Every decision you make from now on will be scrutinized. Every case will be appealed. Every ruling will be questioned." Coretta didn't step back, didn't flinch. "Then I'll make sure my decisions are unimpeachable. That my rulings are grounded in law and evidence. That my conduct gives them nothing to use." She met his eyes. "I've been doing this for 30 years, Mr. Webb. I know how to be a judge. The question is whether your clients know how to be citizens." Webb held her gaze for a long moment. Then he turned and walked away. Coretta watched him go, knowing this wasn't over, knowing the real fight was just beginning. The next 2 weeks moved in waves of action and reaction. The media coverage exploded. A federal judge describing discrimination she'd experienced in state court. The story led evening news broadcasts, spawned opinion columns, generated social media storms. #Justice. For All trended for 3 days. Court reform advocates cited her testimony. Critics accused her of grandstanding. Sterling Whitmore's attorneys responded with a flurry of filings. Ethics complaints against Coretta for improper public statements about pending matters. Motions to dismiss the FBI investigation as fruit of the poisonous tree. Emergency petitions to Judge Becker for expanded restraining orders. Becker granted some, denied others. His rulings were inconsistent, clearly designed to slow the investigation without completely blocking it. Each decision bought the network more time to move money, destroy evidence, coordinate stories. But the safety deposit box documents were already in FBI custody. The financial trail was already mapped, and more witnesses were coming forward. 3 former Whitmore employees contacted Torres with information about the shell corporations. 2 city council staffers provided emails showing coordination between officials and developers. A retired police officer, someone who'd been pushed out after asking too many questions, offered testimony about evidence tampering. The network was cracking, slowly, from the inside. And then, on day 12, the anonymous caller made contact again. The call came at midnight. Coretta was in the hotel room that had become her temporary home, reviewing briefs for cases that had nothing to do with Morrison or Whitmore or the conspiracy she'd stumbled into. The ordinary work of federal jurisprudence continued regardless of whatever storms raged around it. "You did well." The familiar voice. Calm. Measured. Satisfied. The censure was less than he deserved. The censure was more than they expected to give. You shifted the calculation, made it impossible for them to protect him completely. 1 magistrate in 1 courtroom. The network is still functioning. The network is bleeding. 3 more witnesses came forward today. 2 of them have financial records they haven't shared yet. Records that connect Whitmore to Judge Becker. Coretta sat up straighter. Becker is on the take? Becker has been protecting the network for 12 years. His daughter is their primary legal counsel. His rulings have consistently favored defendants connected to the conspiracy. It's not coincidence, it's coordination. We need evidence. You'll have it, tomorrow. Same method as before. Another safety deposit box? Something better. A witness. Someone who's been inside the network for years. Someone who's ready to talk. Who? You'll find out tomorrow. Virginia National Bank. Same location. Box 2891 this time. Why not just tell me now? The caller paused. When they spoke again, their voice was softer. Because some things need to be discovered, not explained. Because you need to see for yourself what you're dealing with. And because I want you to understand why I've been fighting this for 3 years. You keep mentioning 3 years, the car accident, the death that wasn't real. It was real enough. The person I was died that night. What came back was something different. Someone who'd seen too much to stay silent, but knew too much to survive speaking. And now? Now I have protection. You, the FBI, the publicity you've created. For the first time in 3 years, I can move without looking over my shoulder. You're going to come forward. I'm going to finish what I started, one way or another. The line went dead. The safety deposit box contained 3 items: a photograph, a thumb drive, and a handwritten note. The photograph showed 2 men shaking hands in front of a construction site. One was Sterling Whitmore, younger, leaner, but unmistakably him. The other was a face Coretta recognized from news coverage. Harold Becker. 15 years ago, before his appointment to the federal bench. The note was simple. The thumb drive contains recordings. 14 months of conversations between Becker, Whitmore, and others. Everything you need to take down the network. But first, you need to talk to the person who made these recordings. She's waiting at the address below. An address in Alexandria, a coffee shop Coretta had passed 100 times, and at the bottom, a name: Diana Reeves. The woman you think died 3 years ago. The coffee shop was empty except for a woman in the corner booth. She was younger than Coretta expected, mid-30s, with sharp features and watchful eyes. She wore dark clothes, practical shoes, the kind of outfit that allowed quick movement and minimal attention. Coretta approached, sat down across from her. Diana Reeves. The woman nodded. Judge Ashford, thank you for coming. You've been my anonymous caller. For the past month, yes. Before that, I was just someone trying to survive long enough to see justice done. Tell me about the car accident. Diana's expression flickered, memory surfacing. It wasn't an accident. It was an attempt to silence me. I was a paralegal at Bridget Loring's firm before she partnered with her father. I saw things, documents that shouldn't exist, payments that didn't make sense, patterns that pointed to something much larger than normal legal practice. And you started recording. I started documenting, building a case, thinking I could take it to the authorities, expose everything, and walk away with my life intact. She shook her head. I was naive. The authorities I tried to report to were part of the network. The detective who took my statement, he called Whitmore before I left the station. Within 48 hours, my brakes failed on a highway exit. But you survived. Barely. The car went into a ditch. I managed to crawl out before it caught fire. When the police arrived, they found a body, someone the network had put in my place. Jane Doe, never identified. They wanted you dead. They wanted me silenced. When the car burned with what they thought was my body inside, they stopped looking. I became a ghost, moved from city to city, kept copies of everything I documented, waited for the right moment. And now is the right moment? Diana met her eyes. Now there's someone powerful enough to protect me. Someone the network can't easily silence. someone who's already put herself in the crosshairs. You used me. I gave you tools, the safety deposit box documents, the financial trail, all the evidence you needed to understand what you were dealing with. Evidence you could have given to the FBI directly. Evidence the FBI might have lost, might have buried, might have delivered straight to the people I was trying to expose. Diana leaned forward. I told you, there are people in every institution who work for the network. I couldn't risk trusting the wrong person. But you? I watched you in that courtroom. Watched you beat Sterling Whitmore with nothing but a folder and the truth. I knew you were different. Coretta absorbed this. The manipulation, the careful positioning, the months of preparation that had led to this moment. The thumb drive, the recordings, they're authentic? Every one. I recorded conversations for 14 months before the car accident. Whitmore, Loring, Becker, city council members, police officials. They talked openly in that office because they thought they were safe. They weren't. And you're willing to testify. Diana's expression hardened. I'm willing to burn it all down. I lost 3 years of my life because these people thought they were untouchable. I watched them destroy evidence, intimidate witnesses, corrupt institutions that were supposed to protect ordinary citizens. I'm not going back to hiding. Not anymore. She reached into her jacket and produced a small device, a digital recorder. This is the last piece, a conversation from 2 days ago. Whitmore and Becker discussing how to handle the FBI investigation, how to make the charges go away, how to silence anyone who threatens them. She set the recorder on the table. Listen to it. Then decide what happens next. The recording was 23 minutes long. Coretta listened in the coffee shop, Diana silent across from her, the outside world continuing oblivious to what was unfolding inside. Whitmore's voice, stressed and angry. The restraining order isn't holding. They're finding workarounds, other jurisdictions, cooperating witnesses. Becker's voice, calm and judicial. Then we accelerate the timeline, move the remaining assets offshore, create distance between the network and the paper trail. And Judge Ashford? A pause. Coretta felt her pulse quicken. Ashford is a problem that requires careful handling. Direct threats haven't worked. Legal pressure hasn't worked. She's too visible now for other solutions. So what do? We discredit her. Find weaknesses in her record. Old cases with questionable rulings, conflicts of interest, anything that raises doubt about her judgment. And if there's nothing to find? Another pause. Longer this time. Then we create something. The recording continued. Discussions of evidence destruction, witness intimidation, the mechanics of a conspiracy protecting itself from exposure. When it ended, Coretta sat in silence for a long moment. This is enough to bring down Judge Becker. Enough to expand the FBI investigation dramatically. Enough to finally crack the network open. That's why I recorded it. That's why I've been waiting 3 years. Diana's voice was steady, but something burned beneath the surface. The fury of someone who'd been silenced and discarded, now finally able to speak. I want them destroyed, Judge Ashford, not just arrested, destroyed. Their careers, their reputations, their comfortable lives. I want them to lose everything the way I lost everything. That's not how justice works. Then make it work that way. Coretta looked at the woman across from her, the survivor, the ghost, the weapon that the network had inadvertently created by trying to destroy her. I can't promise destruction. I can promise accountability, investigations, trials, consequences determined by law and evidence. And if the system protects them again, if Becker finds another judge to block the investigation, if Whitmore buys his way out, then we document it, expose it, make the protection visible the same way we made Schofield's bias visible. Coretta gathered the recorder and the thumb drive. You've given me weapons. Now let me use them properly, by the book, through channels that can't be dismissed or discredited. Diana stared at her for a long moment. Then she nodded. You're the judge. I'm just a witness. But promise me something. What? Promise me you won't give up, no matter how hard they push back, no matter what they threaten. Promise me you'll see this through. Coretta thought about the photograph in her mailbox, the black rose in her kitchen, the voice on the recording discussing how to handle her. I promise. The next 72 hours moved with the precision of a military operation. Torres took custody of the recordings, chain of evidence established, authentication begun. Each conversation on the thumb drive transcribed, time-stamped, and verified against known voice samples. Diana Reeves emerged from hiding and entered federal protection. Her testimony was recorded in a secure location, her identity still protected from public disclosure. The woman who'd been dead for 3 years was alive again, and ready to speak. The FBI expanded its investigation to include Judge Harold Becker. A federal judge investigated for corruption. The implications reverberated through every courthouse in the Eastern District. Becker's rulings were stayed pending review. His cases reassigned. His chambers searched under a warrant signed by a judge from the Fourth Circuit, someone with no connection to the network. What they found was damning. Financial records hidden in false-bottomed drawers, a burner phone with encrypted messages, and photographs of people who'd been problems for the network, with dates and annotations that suggested surveillance and planning. The Morrison case, the corruption prosecution Coretta had been threatened over, was finally able to proceed. Witnesses who'd been intimidated came forward. Evidence that had been suppressed emerged. The trial date was set for 3 months out, and Sterling Whitmore, watching his world collapse, made one final desperate move. The attack came on a Thursday morning. Coretta was walking from the parking garage to the federal courthouse, Okonkwo 2 steps behind, when a vehicle jumped the curb. Black SUV, tinted windows, accelerating toward them. Okonkwo moved before thought. His body collided with Coretta's, driving her behind a concrete pillar as the SUV's mirror clipped the spot where she'd been standing. The vehicle careened past, jumped back onto the street, and disappeared around a corner. The entire incident lasted 3 seconds. Coretta found herself on the ground, Okonkwo shielding her with his body, his weapon drawn and tracking the empty street. "You okay?" His voice was tight. "I'm okay. Stay down." She stayed, listened to sirens approaching, felt her heart hammering in her chest, the first real fear she'd allowed herself to feel since this began. They'd tried to kill her, in broad daylight, outside a federal courthouse. The network was no longer trying to intimidate. They were trying to eliminate. The SUV was found abandoned 6 blocks away. Stolen plates, wiped for prints, no witnesses who could identify the driver. But security cameras caught the vehicle's approach, and one camera, mounted on a nearby restaurant, captured something else. The driver's face, visible for half a second as he checked his mirror. Victor Holt, the former police officer, the man with lock-picking training who worked for the security company connected to the network, the man who'd broken into Coretta's home. FBI agents arrested him within 4 hours. He was in custody before sunset, his lawyer, not Bridget Loring, who was facing her own problems, already negotiating terms. "He'll flip," Torres said that evening. "He's looking at attempted murder of a federal judge. That's 30 years minimum. He'll give us everyone to avoid dying in prison." "And Whitmore?" "Warrants are being prepared. We arrest him tomorrow morning." Coretta nodded, the walls closing in, the network finally facing consequences. "What about Becker?" "Different process. He's a sitting federal judge. We have to go through the Judicial Council first, but with the evidence we have, the recordings, the documents, the photographs, removal is inevitable. Criminal charges will follow." "How long?" "Months. Maybe longer. Federal judges have protections, due process requirements. It can't be rushed." Coretta understood. The system she'd sworn to uphold required patience, even when dealing with those who'd corrupted it. That was the price of legitimacy, the cost of doing things right. "And Diana Reeves?" "Still in protection. She'll testify at trial. Her recordings are being authenticated by 3 different experts. By the time this reaches a jury, there won't be any question about what Whitmore and Becker were planning. The arrest came at dawn. Coretta watched from a distance as FBI agents surrounded Sterling Whitmore's Alexandria estate. Watched as they breached the door, secured the premises, brought out a man in handcuffs who no longer looked confident or powerful. He looked broken, confused, like someone who'd always believed the rules applied to other people, finally discovering they applied to him too. His eyes found Coretta across the street. For a moment, their gazes locked. She didn't look away, didn't flinch, just watched as federal agents loaded him into a vehicle and drove away. Okonkwo stood beside her. "How does it feel?" "It doesn't feel like victory. It feels like a start. Most people would call this a win. Most people don't know how much is left to do." She thought about the network, the city council members still in office, the police officials still on the force, the systems and structures that had enabled corruption for years and would continue enabling it unless fundamentally changed. Whitmore was one man. Becker was one judge. Their removal was necessary but not sufficient. "The work continues," she said. "It always does." The settlement in her small claims case arrived exactly 14 days after the courthouse hearing. $47,450, wire transferred to an account she'd set up specifically for this purpose. Coretta signed the papers, donating the entire amount to 3 legal aid organizations, groups that helped pro-se litigants navigate a system designed to defeat them, groups that trained advocates to do what she'd done, fight back with evidence and persistence. It wasn't enough. It was never enough. But it was something. 3 months later, the Morrison trial began. Coretta couldn't preside. She was a witness now, not just a judge. The case had been reassigned to a colleague from the Fourth Circuit, someone with no connections to Virginia politics or the network that had corrupted them. The trial lasted 6 weeks. Whitmore and 14 co-defendants faced charges of conspiracy, wire fraud, money laundering, and deprivation of civil rights under color of law. The evidence was overwhelming: financial records, recordings, testimony from witnesses who'd been silent for years and were finally able to speak. Diana Reeves testified for 3 days, described the firm where she'd worked, the documents she'd seen, the attempt on her life and the 3 years of hiding that followed. Her voice never wavered, even when defense attorneys tried to discredit her, to portray her as unstable or vengeful. She was a survivor. Nothing they said could change that. The jury deliberated for 4 days. When they returned, the verdicts were unanimous. Guilty on all counts. For all defendants, sentencing would take months. Appeals would take years. The wheels of justice grinding slowly, as they always did, but grinding forward, for once in the right direction. Coretta sat in her chambers on the day of the verdict, watching the news coverage on muted screens. The celebration outside the courthouse, the families of victims who'd waited years for this moment, the advocates who'd fought for accountability long before anyone in power was willing to listen. Diana Reeves appeared briefly on camera, declining interviews but offering a statement through her attorney. She was rebuilding her life, moving forward, finally free from the fear that had defined 3 years of existence. Okonkwo knocked on the open door. "The protective detail is being reduced. Threat assessment shows the network is effectively dismantled. No more coordinated danger." "And the individual threats?" "Being monitored. But the people who wanted you silenced are in custody now. The rest are focused on saving themselves." Coretta nodded. The weight she'd been carrying for months, the constant vigilance, the awareness of being watched and hunted, began to lift slightly. "What about Schofield?" "Still on the bench, still under audit. 2 complaints filed against him since the censure, both substantiated. The board is watching. But he's still serving. For now, the system moves slowly." She turned back to the window, the city spread out below, the same view she'd seen 1,000 times, but different now, changed by what had happened, by what she'd helped make happen. "It's not enough." "No, But it's more than before. She thought about the small claims courtroom, the clerk who'd obstructed her, the bailiff who'd hidden her evidence, the magistrate who'd rushed her testimony while giving her opponent unlimited time, small corruptions, everyday injustices, the pattern that made larger corruption possible. There's work to be done. There always is. She picked up the next case file. The ordinary business of justice, continuing regardless of whatever victories or defeats had come before. The system was flawed, broken in ways that couldn't be fixed by any single prosecution or any single judge. But it was the system she'd sworn to uphold, the only system that existed. And as long as it existed, there were people like her, people who'd seen how badly it could fail and were determined to make it better. One case at a time, one decision at a time, one small victory that might lead to something larger. The phone on her desk buzzed, a text from an unknown number. Thank you for everything. The work continues. Diana Reeves, still watching, still fighting. Coretta smiled slightly, set down the phone, opened the case file. The work continued. 6 months after the Morrison verdict, the reforms began. The Alexandria General District Court received a new magistrate. Harlan Schofield had resigned quietly, citing health reasons, avoiding the suspension proceedings that had been gathering momentum. He kept his pension, kept his reputation, diminished but intact, faced no criminal charges. It wasn't justice, but it was removal, a small crack in a system that protected its own. Nolan Fry, the clerk who'd challenged Coretta's filing, was transferred to a records department with no public contact. Tucker Gaines, the bailiff who'd hidden her evidence, faced disciplinary proceedings and was ultimately terminated for cause. Bridget Loring surrendered her law license rather than fight the state bar's charges. The suspension of her bar membership would have been temporary. Her reputation would never recover from what the investigation had revealed. She moved to another state, started over, became someone else. Judge Harold Becker's removal took 18 months. Federal judicial discipline moved slowly, deliberately, with every procedural protection the Constitution afforded. But it moved. He was impeached by the House of Representatives, convicted by the Senate, and removed from office, only the 9th federal judge in American history to face that fate. Criminal charges followed, trial pending, appeals certain. The network was dismantled, the conspiracy exposed. The people who'd profited from corruption were facing consequences, but the systems that had enabled them remained. Modified, monitored, improved in small ways, but fundamentally the same. That was the truth Coretta had learned, the hard truth. Justice wasn't a destination, it was a process, endless, imperfect, requiring constant attention and effort and vigilance. The work never ended, but sometimes it produced results. On the anniversary of her small claims hearing, Coretta returned to the Alexandria courthouse. Not for a case, not as a litigant, just to see. The building looked the same. Worn floors, fluorescent lights, security lines moving slowly, people clutching folders and rehearsing arguments, hoping for justice they might not receive. She walked through the lobby, past the checkpoint, toward the courtroom where she'd faced Sterling Whitmore a year ago. The new magistrate was on the bench, a younger woman with patient eyes and a reputation for fairness. The docket moved efficiently, but not rushed. Each litigant received attention. Each case received consideration. Coretta watched from the gallery for an hour, saw pro se plaintiffs treated with respect, saw objections evaluated on merit rather than who raised them, saw something that looked like the system working the way it was supposed to work. It wasn't perfect, couldn't be perfect, but it was better. She left without speaking to anyone, without revealing who she was or why she'd come. Just an ordinary woman in a simple dress, walking through a courthouse, watching justice being done. That evening, she sat in her home, her real home, finally safe enough to return, and opened the mail that had accumulated during the day. Bills, catalogs, the usual detritus of modern life, and one envelope with no return address. Familiar format, familiar weight. Inside, a single photograph. Her own face, smiling slightly, standing in the gallery of the Alexandria courthouse earlier that day. The angle suggested a phone camera. Someone close, someone watching. On the back, handwritten, "The work continues, always." And beneath it, another line. "Thank you for showing them it's possible." No signature, no identifying marks, just Diana Reeves, somewhere out there, still watching, still fighting, still refusing to let the silence win. Coretta set down the photograph, looked around her kitchen, still the original cabinets, still the original countertops, still the space that had been violated and reclaimed. The network was broken. The immediate danger was past. But somewhere, other networks were forming. Other corruptions were taking root. Other people were being silenced, dismissed, destroyed by systems designed to protect power rather than serve justice. The work continued. It always would. She picked up the phone and dialed a number from memory. "Torres, it's Judge Ashford. I have something I want to discuss, a pattern I've been noticing in some recent cases. Nothing as dramatic as Morrison, but worth looking into." On the other end of the line, Agent Torres laughed softly. "You never stop, do you? I made a promise, to keep fighting, no matter what." "All right, I'm listening. What do you have?" Coretta opened the file she'd been reviewing. New evidence, new concerns, new injustices that demanded attention. The work continued, and she was just getting started. The end. This story showed what happens when someone refuses to be silenced. If you want to see more stories of accountability and justice, subscribe now, because the next one is already in production.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.